When the courtroom asks, "Did you know it was wrong?" She planned it. She did it. And afterward, she sat down, quietly, like it didn't matter. The courtroom didn't know what to make of her. Her lawyer stood up and said the words that always change everything. Not guilty by reason of insanity. But what does that really mean? Let's slow this down. When we hear the word insane, we often picture something wild, loud, chaotic. But legal insanity is something different. It's not about what someone looks like. It's about what they understood at the exact moment they committed the act. In most courts, being legally insane means one very specific thing. You didn't know what you were doing, or you didn't know it was wrong. That's it. That's the whole definition. And because it's so narrow, it often leaves out many people who seem mentally unwell, but who still get punished. Let's say someone has a mental illness. Maybe they have paranoid thoughts. Maybe they hear voices. Maybe they feel completely disconnected from others. But if they still understand that what they're doing breaks the law, they're not legally insane. That's the strange part. You can be emotionally unstable, morally confused, deeply unwell, and still be found legally sane. Because the law isn't asking how you felt. It's asking what you knew. Did you understand the rule you were breaking? And so, someone with deep psychological struggles can go to prison, while someone else, who may have lost touch with reality entirely, goes to a psychiatric hospital instead. Now pause here. Neither path is easy. People often think insanity means getting away with it. But psychiatric hospitals are not places of freedom. Many who go there stay longer than they would in prison. They're medicated, watched, evaluated, sometimes for years, sometimes for life. And then there's the other problem. Juries don't always believe it. If someone looks calm, if they speak clearly, if they don't act crazy, jurors might think they're faking it. But real mental illness doesn't always look dramatic. Often, it's quiet. It doesn't scream. It waits in the background. That's why so many people with mental illness still end up in prison. The legal system wasn't built to understand emotional depth. It was built to answer yes or no questions, guilty or not, sane or insane. But human minds aren't that simple. A person can be broken in ways the court doesn't recognize. She might feel no remorse. She might not understand human connection. She might not even remember the event clearly. But if she knew it was against the law, the court says she's sane. That's the heart of this quiet paradox. You can be morally lost and legally sane. You can be emotionally hollow and still held fully responsible. The court only wants to know, did you understand the rule? Let's take a closer look at why this distinction matters so much. When the law draws a line, sane or insane, it treats it like a switch. On or off, yes or no. But the human mind doesn't switch. It slides. It slips. It moves through gray areas that the courtroom can't always see. A person might prepare for a crime in a way that looks rational. Buy supplies, plan an escape, avoid cameras. But at the same time, they might be convinced they're doing something good, or necessary, or even moral. Maybe they believe they're protecting someone. Maybe they think they're following a divine command. To them, it makes sense. To the law, it doesn't. And so, we punish the act, not the reality they were living in. Sometimes, someone with a severe disorder will commit an act of violence with no clear motive. They might be experiencing hallucinations. They might be under the grip of fear, so deep it feels like survival. But if they understand, even slightly, that what they're doing is against the law, they are declared sane. Now imagine this playing out in court. The jury listens. The defendant looks calm. Maybe they even seem polite, respectful. The doctors speak in careful terms, delusions, diminished capacity, auditory hallucinations. But the jury wants clarity. They want a bad person or a sick person, not someone who might be both, or neither. And so they choose the simpler path, guilty. Why? Because insanity feels messy, uncomfortable. It doesn't give people closure. Punishment does. A sentence feels like an answer. A hospital feels like an open question. But what happens after the sentence? A person with untreated mental illness often enters a prison system that isn't designed to help them. They're punished for behaviors they don't fully control. They may isolate. They may deteriorate. And by the time they're released, they may be worse off than before. This isn't just a legal problem. It's a moral one. Because when we fail to recognize mental illness in the courtroom, we end up blaming people for symptoms, not choices. We call something evil when it might have been pain. We name someone a criminal when they might have been lost. None of this means we let people go without consequences. But maybe we need more than just consequences. Maybe we need a justice system that includes reflection, care, complexity. There's a phrase used in some legal systems, guilty but mentally ill. It's meant to be a middle ground. It says, yes, you broke the law, but your mind wasn't whole. You'll go to prison, but you'll also get treatment. It sounds balanced, but it rarely works. Often, the treatment never comes. The label changes nothing. It's just words. Because at the end of the day, our system still struggles to see mental health as real unless it's dramatic, obvious, loud. But most mental illness isn't loud. It's quiet, private, internal. And that's what legal insanity fails to capture. It's not about what someone looks like. It's about what they were living through, inside their own mind, at the moment everything went wrong. That's why this topic matters, not just for courts, but for all of us. Because justice that can't understand the mind will always fall short of the truth. Let's look at how this plays out in a real case. In 2001, a woman named Andrea Yates drowned her 5 children in a bathtub. The country was horrified, but the case didn't fit the usual pattern of cruelty or anger. Andrea had long been diagnosed with severe postpartum psychosis. She believed she was saving her children from eternal damnation. Her mind had created a world where this was not a crime, but an act of protection. The court at first found her guilty. Then, after appeal, a new jury found her legally insane. This wasn't an easy decision. Many people were angry. They asked, how could someone do something so terrible and not be held responsible? But that's the point. In her mind, Andrea Yates wasn't doing something terrible. She was doing what her illness convinced her was right. This doesn't make the tragedy smaller, but it makes the truth harder. Now imagine that case without doctors, without medical records, without a history of treatment. Would the jury still have believed her? Would she have had a chance to explain a mind that had turned against her? That's the danger. We think we understand the mind by watching the surface, but real understanding takes time, listening, empathy, none of which fit easily in a courtroom clock. Legal insanity isn't a soft excuse. It's a hard truth, sometimes. People lose themselves. And when they do, what they do can still cause harm, but not always in ways they chose. This isn't just about crime. It's about how we see people. When we look at someone who did something awful, we often stop asking questions. We stop imagining the path that led them there. But justice isn't just about reacting. It's about understanding how things happen, so they might not happen again. And here's what's often missing. The person who committed the act under mental illness, if they recover, often lives with a deep, quiet pain. They learn, later, what they did. They begin to understand the loss, the damage, the grief they caused, and they carry that for the rest of their life. It doesn't make things right, but it reminds us, punishment isn't the only weight people bear. So what does all this mean? It means we should think more slowly, judge more carefully, and accept that not all answers come in the form of a sentence. When the law says someone is insane, it's not saying they're free. It's saying their mind broke. And maybe, before we punish, we need to understand what that really means. Because justice that listens is justice that lasts. The ship of Theseus in criminal trials. If everything changes, is it still the same crime or the same person? He was 16 when it happened. It wasn't a plan. It wasn't thought out. It was a moment, one decision, and then a chain of events he couldn't stop. But the trial didn't happen until he was 25. Now he's standing in a courtroom, neatly dressed, employed, quiet. He doesn't even remember it clearly. The prosecution does. They describe it in detail. But the boy who did that, he's gone. In his place stands a man who reads bedtime stories to his child and volunteers on weekends. The law asks, is he the same person? This is the ship of Theseus in criminal trials. A slow, unsettling question. If everything changes, your body, your mind, your past, are you still accountable for the crime you committed? Let's take it slowly. In philosophy, the ship of Theseus is an old puzzle. If you replace a ship's parts, one by one, is it still the same ship? And if you gather all the old parts and rebuild them into a new ship, then which one is the real one? Now apply this to a person. Over 10 years, everything in them may have changed. Thoughts, habits, goals, memories, even the way they understand right and wrong. Are they still the same person who stood at the beginning of that timeline? Legally, yes. The law looks at the moment of the act. What did you do? Was it against the law? Were you responsible? But emotionally, it's more complicated. We are not the same year to year. Experience reshapes us. Age, grief, recovery, trauma, they change our internal parts. And in criminal justice, this raises a quiet, unresolved question. Are we judging the act or the person? Let's look at what happens when a case drags on. Memories fade. Witnesses disappear. The law may even change. A sentence that once seemed obvious now feels outdated. The courtroom is full of files, but light on certainty. The person sitting there has aged. They've built a new life. Or maybe they've unraveled more. Either way, they're not who they were. But the system doesn't pause for growth. It holds time still. It says, this is what you did, and this is what you get. That's the paradox. We ask people to grow, to change, to reform. But then we judge them for the version of themselves they've left behind. Some countries handle this by leaning into rehabilitation. They say, let's look at the person now. What's useful? What's fair? Others stay strict. The act matters, not the evolution. Justice, they say, must be blind to time. Neither answer is perfect, because sometimes people change for the better, and sometimes they don't. And the courtroom, built for evidence and rules, isn't always designed to know the difference. Now imagine a child. A teenager makes a mistake, serious, but rooted in impulse, confusion, fear. The legal process moves slowly. By the time it finishes, that teenager is now an adult. Do we sentence the child or the adult? Do we freeze their identity at that moment forever? Or imagine someone who has transitioned, name changed, gender changed, community changed, a life built new, but a case from long ago resurfaces. Is it still the same person? In law, identity is treated as fixed, but real life is more like the ship. Parts change, not all at once, slowly, quietly, until what stands before us is not who stood there before. Some legal models try to respond to this. Restorative justice, alternatives to prison, community dialogue. These systems ask a different question. What needs to be healed? Not just what needs to be punished. But most systems don't work that way. They're built to prove, to assign, to close, not to listen to who someone has become. And so people are sentenced not just for what they did, but for who they used to be. It's easy to miss how heavy this is. Easy to focus on guilt or innocence, on verdicts and facts. But underneath it all is a quieter truth. The law isn't just about rules. It's about time. And time changes everything. So when we ask, is this the same person who committed the crime? What we really mean is, can the law afford to notice that they're not? Because if it does, it might have to change too. Let's take a moment to consider the cost of waiting. When a case stretches over 10, 15, 20 years, it doesn't just test the memory. It tests the meaning of justice. What does it mean to hold someone accountable after everything about them has changed? The legal system says we must, because the past matters. But time has a way of shifting context. Evidence grows cold. Technology improves. Cultural norms evolve. A sentence that once seemed fair might now feel harsh, out of step with current values. And what about the people left waiting? Victims wait for resolution. Their pain may soften or grow sharper with time. The longer they wait, the harder it becomes to know what justice should look like. They may have imagined the person responsible as frozen in time. But in court, they face someone different, older, quieter, maybe remorseful. That can feel like betrayal, or healing, or both. And the accused? They wait too, with uncertainty, with fear. Sometimes with hope that they can prove they've changed. Sometimes with guilt so large it never leaves. Waiting doesn't erase the crime, but it erodes the simplicity of response. The longer we wait, the less we remember why it all started, and the more we have to ask what we're trying to do now. Is it punishment? Is it closure? Is it prevention? And if it's prevention, what exactly are we preventing? If the person has already become someone new? There's another layer here. Legal identity is often treated as continuous. You are always the same, you, in the eyes of the system. But psychological identity doesn't work like that. We become different versions of ourselves across time. Not always better, not always worse, but undeniably different. So when we say, he must pay for what he did, we're often speaking to a ghost. The boy who made that choice isn't the man standing in court. The mind that acted has been slowly taken apart, rebuilt with new habits, new experiences, and sometimes regret. That's not an excuse. It's a reality. And the legal system, built on logic and order, doesn't always know what to do with human reality. Some judges try. They ask deeper questions. They consider who the person is now. They look beyond the file. But the system doesn't always give them room for that. Guidelines, minimums, precedents. The framework demands consistency, even when the truth doesn't. And so people get sentenced for things they did long ago, in a life they barely recognize, by a system that still sees them as frozen in time. This isn't about letting people go. It's about understanding what justice becomes when time changes the person we're judging. Because maybe the hardest truth is this: we all change. And if we're lucky, we change in ways that make us less likely to harm others. But the law doesn't always reward change. It recognizes only what can be proved. So what do we do with that? Maybe we start by listening more carefully. Maybe we create space for time inside the courtroom. Maybe we accept that justice, to be real, must do more than remember the past. It must also understand the present. And maybe, just maybe, it must find a way to hold both at once. Let's look at a real example. In Canada, a young man committed a robbery when he was 17. It was reckless. He was scared. He didn't think about consequences. The case took nearly a decade to resolve. By then, he was 27, stable job, no new charges, clean record. When sentencing finally came, the judge faced a quiet dilemma. Do I sentence the boy or the man? The law required a decision. The sentence was reduced, but the questions remained. Who are we judging? Who is being punished? In another case, a woman involved in a small protest was charged with trespassing and resisting arrest. The case stayed open for over 12 years. In that time, the laws had shifted. The charges now seemed excessive for what had happened. When her case resurfaced, she was a mother, a teacher, no longer involved in activism at all. The judge dismissed the case, but not without debate. These are not rare stories. They happen quietly, all over the world. Cases lost in backlog. People caught between timelines. The law moves slowly. Lives move fast. What's lost in this gap? Maybe it's a sense of fairness. Maybe it's a chance for better outcomes. Or maybe it's just the humanity that gets forgotten when people become paperwork. And yet, this isn't a flaw. It's the core of the system we've built. One that struggles to keep up with the pace of personal growth. One that freezes people in time and calls it justice. So what can be done? Some call for time limits on prosecution. Others argue for more flexibility in sentencing. Still others suggest a bigger shift, designing justice not as a system of reaction, but of transformation. One that asks, what kind of person stands here now? What do they need to do right by the harm caused? What does the community need to feel safe? Because when the person, the story, and the system have all changed, there may be no clean answer. And maybe that's okay. Maybe justice doesn't need to be perfect. Just aware. Aware that a person can be one thing at 16 and another at 30. That time doesn't undo harm, but it does reveal whether someone can grow past it. The ship of Theseus wasn't meant to have a clear solution. It was meant to show us the limits of simple thinking. So maybe the lesson here isn't about crime or law, but about change. People change. Slowly. Quietly. Sometimes beautifully. And justice, if it wants to be real, has to find a way to follow them. Stealing out of hunger. When the need to survive quietly breaks the law. A man walks into a store. He doesn't look like a threat. He doesn't shout. He doesn't carry a weapon. He walks to the back, picks up a loaf of bread, and tucks it into his coat. Then he walks out. The security guard stops him. The police are called. Later, in court, the charge is clear: theft. But the man doesn't argue. He only says one thing: I was hungry. This is the starting point of something much bigger. The question of stealing out of need. When survival is the reason, and the law still calls it a crime, something feels off. Not because stealing is right, but because hunger isn't simple. Let's stay with this slowly. Let's look at what the law says, what the mind feels, and what it means to live in a system where saving your own life might be illegal. Let's start with what the law often says. In most places, theft is theft. If you take something that doesn't belong to you, it's a crime. The law doesn't always ask why you took it. It only asks what you took, and whether you had the right to do it. But the human side of the story isn't so clean. A person who steals food isn't always trying to get ahead. They're often just trying to stay alive. And in that moment, when the stomach aches louder than the law, some people choose bread over rules. That's where the idea of necessity comes in. It's a legal defense, a narrow one. It says, I broke the law. Yes, but only because I had to. Because the alternative was worse. In theory, it makes sense. In practice, it's hard to use. Most courts require strict proof. You must show that you had no other choice. That there were no shelters, no food banks, no relatives to call. That you couldn't have waited. That the harm you were trying to avoid, like starvation, was more serious than the crime you committed. That's a hard thing to prove, because hunger doesn't always look desperate, and need doesn't always come with paperwork. Some countries handle this with more flexibility. In Italy, a court once ruled that a homeless man who stole food worth a few euros should not be punished. The court said his basic right to survive was more important than the store's right to its property. That ruling wasn't about erasing the theft. It was about acknowledging the context. But in many places, context isn't enough. Judges and prosecutors often worry. If we allow need as an excuse, where do we stop? What if others start stealing for comfort, not survival? What if this opens a door the system can't close? So the law stays firm, even when the heart hesitates. But there's something deeper here. When someone steals out of hunger, it's often not their first step into crisis. It's their last. They've already slipped through gaps, lost jobs, lost homes, maybe lost help they once had. By the time they steal food, they've already been punished, just not by the court. And yet, it's in the courtroom that we decide who they are. The law calls them a thief, but they might just be someone who was ignored too long. This creates a strange kind of story, one where the punishment isn't for the theft, it's for being left behind. And that makes the law feel heavier than it should. Because when someone's crime is trying to survive, we have to ask, what kind of justice do we want? One that protects bread on a shelf? Or one that understands why someone needed it? These aren't easy questions, but they are necessary. Because at the center of all this is a human being. Not just what they did, but what they faced. And what the system did, or didn't do, before they reached for something to eat. Let's pause and ask, what does it mean to be desperate? Not just hungry, but truly without a path forward. No money, no home, no one to call, no shelter that will take you, no government service that can reach you in time. In that moment, morality shifts. Not because the person has changed, but because survival starts to rewrite the rules. They don't think in legal terms. They think in hours, in calories, in how long they can wait before passing out. They're not asking if it's right. They're asking if it's possible. And this is where the law often misunderstands the mind, because the necessity defense isn't built for quiet hunger. It's built for emergencies that can be measured. A fire, a threat, a danger with a timestamp. But starvation doesn't happen like that. It creeps in, quietly, privately, and by the time it's visible, it's already far along. So the court asks, why didn't you ask for help? And the answer, too often, is I did, but no one came. This is why so many people who steal food don't fight the charge. They already feel the weight of failure. They're used to being blamed. The trial is just one more room where their need is seen as guilt. And yet, there's something else happening. Communities around the world are starting to question this. Some have created food banks inside police stations. Others have replaced jail time for food theft with social support or volunteer work. Some cities have quietly stopped prosecuting low-value food theft altogether. These changes don't excuse the action, but they ask better questions. What led to this? What else could have been done? And how do we prevent the next person from reaching this point? Because once someone is hungry enough to steal, they've already been failed. There's also a strange irony in how the system works. We spend more money arresting, processing, and punishing people for stealing food than we would spend feeding them. A loaf of bread might cost a few dollars. The system used to punish its theft can cost hundreds, sometimes thousands. This is more than inefficient. It's irrational. We're using justice to fix something that economics, care, and attention could solve more easily. And when you speak to people who've been through it, you hear the same words again and again. I didn't want to. I was ashamed. I had no choice. They don't describe rebellion. They describe resignation. That's what gets lost when we talk about theft in legal terms. We lose the human rhythm behind it, the long road that led to that decision, and the silence that surrounded them as they walked it. So maybe the law isn't wrong to protect property, but maybe it becomes wrong when it protects property more than people. Let's return to the courtroom. The judge listens. The theft is clear. The defendant is calm. The store lost something small, maybe $5 worth of bread and milk. But the person who took it may have already lost much more. A job, a place to sleep, a sense of dignity. And here is the quiet decision the court must make. Do we punish the theft? Or do we recognize the collapse that led to it? Some judges choose compassion. Others feel bound by the rules. But every time this happens, the same question lingers. Is survival allowed to break the law? It's not easy. If we allow too much, we risk losing structure. But if we allow nothing, we risk losing humanity. In some places, solutions are taking shape. Instead of arrest, a referral. Instead of a record, a connection. Instead of shame, a conversation. What do you need? How did this happen? What can we do? These are not soft questions. They're brave ones, because they refuse to look only at the act. They look at the story, and stories matter. One person stole to feed their child. Another stole to last the weekend. A third hadn't eaten in 3 days. These are not crimes of greed. These are signals, warnings, a society's quiet red flags. Theft out of hunger isn't a loophole. It's a mirror. It shows us where support systems fail, where communities go quiet, where people disappear before they're missed. And the law, if it wants to be just, has to be more than rules. It has to be aware. Because bread is not always about food. Sometimes, it's about being seen. When someone reaches for it, illegally, desperately, we can ask what punishment they deserve. Or we can ask what kind of system lets a person reach that point alone. This doesn't mean there should be no rules. It means the rules should leave space for listening, for humility, for recognizing that not all crimes begin with intent. Some begin with need. And when that need is hunger, the law has 2 choices. It can close the door, or it can open a hand. That decision speaks louder than any verdict. Punishing the past, retroactive justice. Can you be guilty of something that wasn't a crime when you did it? You didn't know it was illegal. At the time, no one did. There was no law yet. No warning. No fine print. Just a decision he made quietly, and without fear of consequence. Years later, a new law passed, and suddenly, what was once ordinary became criminal. Now, someone knocks at his door. They hand him a notice. He's under investigation. The thing he did back then, the thing no one said was wrong, is now punishable. This is retroactive justice. When we look back at the past through the lens of today's rules. And sometimes, we don't just judge. We punish. Let's pause here. Let's sit with the discomfort. Because this isn't about letting people off the hook. It's about asking, can you be guilty of something that wasn't a crime when you did it? And if you can, what kind of justice is that? Let's start with something simple. The principle of fairness. Most people believe that punishment should be tied to choices. If you break a rule, and you knew it was a rule, then you're responsible. That's the foundation of justice. Choice, awareness, accountability. But retroactive laws break that foundation. They reach backward in time. They say, we've changed the rules, and now we will judge your past by them, even if you had no way of knowing, even if your decision, in its moment, was entirely lawful. Most legal systems have tried to prevent this. There's even a Latin phrase for it. Nullum crimen sine leg, no crime without law. You can't be punished for something that wasn't a crime when you did it. This idea sits quietly at the core of many constitutions, including in countries like the US, the UK, Germany, and India. But still, there are exceptions. And in those exceptions, the past becomes uncertain ground. Sometimes, the change is small, an administrative rule, a tax classification, a licensing update. But other times, it's deeper. It involves acts that were once common, even accepted, but that now carry weight. Environmental harms, historical abuses, discrimination that was once overlooked and is now condemned. And then the question appears, what do we do with people who followed the old rules, but harmed others under them? If we let them go, we risk sending the message that harm has no weight. If we punish them, we risk denying that context matters. This isn't just legal. It's emotional. Retroactive justice makes us choose between 2 kinds of fairness. Fairness to the people harmed, and fairness to the people who didn't know they were causing harm. And that's what makes this so hard. Because justice isn't only about what happened. It's about when. And when the law moves faster than memory, people get caught between worlds. One of the most painful examples of this comes from transitional justice, when nations try to reckon with old regimes. After war, after dictatorship, after systemic abuse, new governments want to hold old actors accountable. But the laws those actors broke didn't exist at the time. So courts struggle. Do they create new laws and apply them backwards? Do they try to stretch old ones to fit? Or do they do nothing and live with the silence? None of these paths feel right, but one must be chosen. And here's where the psychology of justice starts to unravel. Because time changes how we see everything. What once felt normal may now feel horrifying. And when we see the past with clear eyes, we want accountability. But the people in the past didn't have those eyes. They lived under different norms, beliefs, fears. And when we forget that, justice turns into punishment without understanding. So what do? Maybe we start by admitting that not all harm fits neatly into the present. That some wrongs can't be measured by today's law, but they can still be seen, acknowledged, grieved. Sometimes, that's what victims need most. Not a sentence, but a recognition that what happened was real and wrong. That's not weakness. It's honesty. And maybe honesty is what the past deserves most. Let's sit with a quiet example. Decades ago, in many parts of the world, certain labor practices were common. Long hours, unsafe conditions, child workers. At the time, companies followed the law. They met the standards of their era. But now, those standards have changed. And people are asking, should companies be held accountable now for what they did then? This isn't just a legal issue. It's a moral one, a generational one. For victims, the harm is still present. They carry the consequences in their bodies, in their health, in their communities. But for those who ran the systems, their defense is simple. We followed the rules. So what happens next? Some countries have offered apologies. Others have created compensation funds. A few have tried prosecutions, quiet, symbolic, not for vengeance, but to make a statement. This mattered. Even if it wasn't illegal, it was wrong. This balance between legality and responsibility is fragile. And it depends on one thing: how a society chooses to remember. Because retroactive justice isn't just about laws. It's about memory. It asks, how do we carry the past? Do we lock it away? Or do we carry it openly, even if it weighs us down? And when we bring it into the courtroom, we ask the law to do something it wasn't built for. We ask it to feel. But courts don't feel. They measure. They interpret. They apply. That's why retroactive punishment often feels so unsatisfying. It stretches the law beyond its design. Not to hurt, but to heal. And law doesn't always know how to do that. So we turn to something else. Truth commissions, public inquiries, collective acknowledgments. These aren't about guilt. They're about truth. And in truth, sometimes, justice becomes softer, but deeper. Because not every wrong needs a punishment. Some need a pause, a name, a space to say, this happened. That, too, is justice. Let's look at another example. In the early 2000s, some countries passed laws to recognize past crimes against indigenous populations, forced removals, cultural erasure, even abuse under official programs. The acts weren't illegal at the time, but they were wrong. Rather than prosecute, some governments chose to apologize. Publicly, they created museums, educational programs, healing initiatives, and in doing so, they sent a message: we see you now. We failed you then. This kind of justice doesn't show up in headlines, but it lives longer. And maybe that's the answer. Retroactive justice doesn't have to mean retroactive punishment. It can mean retroactive care. The difference is small, but the impact is vast. Because when we choose care over condemnation, we don't erase accountability. We make space for it to grow. Let's end where we began. A man opens his door to find the past waiting for him. A rule that didn't exist when he acted. A punishment that now belongs to him. And he's left wondering how the world changed without telling him, and why it wants him to pay for it. This isn't a rare story. It's the quiet tension inside many legal systems. Between the need for order and the need for acknowledgement. Between clarity and compassion. Retroactive laws ask us to judge history. But history was never meant to be judged with today's eyes. It was meant to be learned from. That doesn't mean silence. It doesn't mean letting go of harm. It means using different tools. Maybe not prison, but truth. Maybe not guilt, but memory. Maybe not punishment, but recognition. Because justice, when it looks backward, doesn't need to punish to be real. It needs to understand, and then it needs to speak. So the next time a society considers reaching into its past to punish, maybe it should pause. Ask not just, was this wrong? But also, what do we hope to heal? Because when we reach into history with only punishment, we might bring back more pain than peace. But when we reach with understanding, with patience, and with care, we begin something better. We begin to remember differently. And that, too, is justice. Not written in laws, but carried in how we choose to remember. Pre-crime laws and predictive policing, arresting people for what they might do. He hadn't committed a crime. Not yet. But there were signs. A pattern. A profile. The system flagged him. He was brought in, questioned, watched. Not for what he had done, but for what he might do. This is the world of predictive policing, of pre-crime laws. A world where the future becomes evidence, and suspicion becomes strategy. It sounds like science fiction, but it's not. In quiet ways, in scattered cities. It's already happening. Software that maps crime hotspots. Risk assessments that predict recidivism. Surveillance that doesn't just see, but anticipates. And all of it hinges on one question. Can we punish someone before they act? Let's sit with this. Let's slow it down, because this is no longer about proof. It's about prediction. And once we start treating future intent like present guilt, everything changes. Let's begin with the logic. At its core, predictive policing is built on data. Past crimes, patterns, times of day, types of neighborhoods. Algorithms take that information and look for trends. They tell officers where crime is most likely to happen, and sometimes, who is most likely to commit it. It doesn't sound unreasonable. If we can use data to predict disease, traffic, even weather, why not crime? But people aren't patterns, and predictions aren't facts. The moment you start treating a person as a probability, you stop seeing them as an individual. You start seeing them as a risk score, a red flag, a future problem, and the law begins to move earlier and earlier. Sometimes, this looks like more patrols in high-risk areas. Sometimes, it looks like someone being stopped again and again, not because they did something, but because the system thinks they might. It's subtle, quiet, but it shifts everything. Because once suspicion is automated, it spreads. This creates a new kind of justice, one that doesn't wait for harm. It acts before it happens, not on evidence, but on expectation. This isn't new. Historically, societies have always tried to spot dangerous types. In the past, it was phrenology, then criminal profiling. Now, it's software. The tools change. The instinct remains. But there's a cost. Pre-crime logic turns people into probabilities. It assumes that past behavior, or even association, can predict future choices. But the human mind is not a straight line. It doesn't always repeat. It surprises. It shifts. It learns. And when a system forgets that, it forgets what makes people human. Let's talk about real impact. In many cities, predictive policing tools have led to over-policing in low-income neighborhoods. Areas flagged as hotspots see more patrols, more stops, more surveillance, and the people who live there begin to feel watched, judged, marked, not because of what they've done, but because of where they live. And for those flagged by name, people whose profiles match the algorithm's logic, the consequences are worse. They get questioned more, denied more. Suspicion follows them, silently. Doors close before anything even happens. This is where pre-crime begins to erode something deeper. Trust. Trust in fairness. Trust in neutrality. Trust in the idea that justice waits for facts. Because once prediction becomes enough to act on, justice stops being about what's real and starts being about what's feared. And fear spreads fast, especially when the tools are hidden. Many predictive systems are proprietary. The algorithms aren't public. The data isn't shared, which means you can be flagged, watched, restricted, and never know why. You can't argue with a system you can't see. And that invisibility is what makes this so dangerous. Because without transparency, there's no accountability. And without accountability, there's no justice. So the question becomes, how far are we willing to go to feel safe? And at what cost to the freedom of people who haven't done anything yet? That's where the tension lives. In the space between precaution and punishment. Between wanting to prevent harm and starting to punish the idea of harm. Because when we blur the line between the two, we risk becoming something else. Not a justice system, but a prediction engine. And engines don't care who gets hurt, as long as the numbers look clean. Let's explore something quieter. Imagine a young man who's never committed a crime, but the system marks him as high risk. Maybe because of where he lives. Maybe because of who he's related to. Maybe because his name fits a pattern. He doesn't know this. But slowly, he notices things. He's pulled over more often. Watched more closely. A job application is delayed. A background check needs more time. There's no official record. Just hesitation. Over time, he begins to carry that suspicion himself. He starts to expect it. Starts to avoid places. Avoids people. He steps smaller. Trusts less. This is the emotional cost of being treated like a future threat. Even when nothing happens, something changes. You stop being presumed innocent. You become potentially guilty. And when enough people feel this way, society shifts. Communities become quieter, not because they're safer, but because they're tired. Tired of being flagged. Tired of being tracked. Tired of being told they might be dangerous. And that exhaustion is not justice. It's surrender. Here's another question. What if the system gets it wrong? Algorithms are not neutral. They reflect the data they're fed. If arrests have been unfair in the past, that bias gets baked into the prediction. The system learns the wrong patterns and repeats them. And since these systems are rarely open to the public, we can't check their thinking. We can't say, that's not true, because we don't know what was used to decide. This is how injustice hides. Not loudly, quietly, in lines of code. That's why so many civil rights advocates warn against pre-crime tools. Not because the idea of prevention is wrong, but because the tools aren't built with care. They're built for speed, for scale, for control. And control without understanding always ends up hurting the same people. So what can be done? Maybe the first step is humility. Admit that we can't fully predict the future. That trying to do so, with absolute certainty, is not protection. It's pressure. Then, maybe we build systems that focus on support, not suspicion. If someone is flagged as at risk, why not offer help? Mentorship, resources, opportunity. Treat risk as a chance to intervene kindly, not punitively. Because if we respond to every shadow with a spotlight, we forget how shadows work. They move. They change. They're not proof of danger, just the shape of light being blocked. And people deserve more than to be treated as outlines of what they might become. Let's slow this down one last time. We all want to feel safe. We all want harm to be prevented. But safety built on suspicion is a fragile thing. It doesn't grow trust. It grows distance. And justice, real justice, depends on closeness. On knowing, not guessing. On listening, not scanning. On responding to what is, not what might be. There's a quiet temptation in technology. It offers certainty, speed, efficiency. But people are not problems to be solved by patterns. They are lives complicated, layered, and capable of change. If we forget that, we forget what the law is for. The law is not just a fence. It's a frame. It holds space for fairness, for time, for the full story to unfold. And pre-crime tools threaten that frame. They rush it. They narrow it. They make it afraid. But fear is not a foundation. Not for justice. Not for peace. So maybe we need to be slower, gentler, more human. Instead of asking, who might commit a crime? Ask, who might need support before they break? Instead of policing risk, we could reduce it. Instead of predicting harm, we could prevent it by understanding. Because justice is not just the absence of crime. It's the presence of dignity. And dignity can't be predicted. It has to be protected. So the next time someone says, they haven't done anything yet, maybe the right response is not to watch them. Maybe it's to reach them. Before the data decides who they'll be. Before we forget that they never stopped being human. And before we build a world where the future is not a hope, but a sentence waiting to be written. Diplomatic immunity. When the law backs away from justice. When justice pauses because of protocol. He ran the red light. The police stopped him. But instead of a ticket, he showed a card. A few phone calls later, he was free to go. No fine. No record. Just a quiet reminder. He wasn't bound by the same rules. This is diplomatic immunity. A legal shield that protects foreign diplomats from prosecution in the host country. It was designed to keep diplomacy safe, to prevent harassment, to protect negotiation. But sometimes, it protects more than words. Sometimes, it protects harm. Crimes go unpunished. Victims get no answers. And the law, usually so firm, steps aside. Not because it's fair, but because it's protocol. Let's stay here. Let's understand how justice bends quietly when politics enter the room, and what happens when the law is asked to look away. Let's begin with the purpose. Diplomatic immunity was never meant to excuse crime. It was created to ensure that diplomats could do their jobs without fear. That foreign leaders and envoys wouldn't be arrested or harassed while engaging in delicate negotiations. That politics wouldn't turn into retaliation. And for the most part, it works. It keeps embassies safe. It protects dialogue. It prevents tit-for-tat legal moves between hostile nations. But immunity is broad, and when it's abused, the effects are real and quiet. Consider a case where a diplomat's family member commits a serious crime. Assault, theft, even worse. Local police investigate. They find evidence. They make a request. But the answer comes back the same. Diplomatic immunity applies. The case stops. The person leaves the country. And nothing more happens. To the victim, it feels like vanishing. Like their pain didn't count. And in many ways, that's true. Because diplomatic immunity doesn't only cover officials. It often extends to spouses, children, and staff. And host countries have limited options. They can ask the diplomat's home country to waive immunity. But the answer is often no. Why? Because admitting guilt has consequences. International embarrassment, political fallout, and most governments choose silence over scandal. So the law steps back. Not because the facts are unclear, but because the politics are complicated. This creates a quiet injustice. People hurt by someone with immunity are often told, "There's nothing we can do." They don't get their day in court. They don't get closure. They get a reminder. Some people live under a different set of rules. And that changes how people see the law. Because the law, to most of us, is supposed to be equal. That's its promise. That's what gives it weight. But when that promise breaks, when a person walks free, not because they're innocent, but because they're important, that weight disappears. This isn't about blame. It's about structure. Immunity is built into international agreements. The Vienna Convention on Diplomatic Relations, signed in 1961, outlines the rules. It says diplomats are inviolable. They can't be detained. Their homes can't be entered. Their communication is protected. But the world has changed since 1961. Back then, diplomats were few, known, easily tracked. Today, there are thousands, in large cities, in complex systems, with less oversight. And the shield built to protect diplomacy now sometimes protects things diplomacy never asked for. So what happens when immunity goes too far? Some countries push back. They declare diplomats persona non grata, unwelcome. They send them home. It's a diplomatic penalty, not a legal one. A way to say, we saw what happened. We won't ignore it. But it doesn't undo the harm. It doesn't fix what was broken. And in the public eye, that often feels hollow. Because people don't just want removal. They want accountability. They want the law to mean something, even when it's inconvenient. And here's where things get deeper. Because once immunity becomes a way to avoid justice, it starts to lose its legitimacy. It's no longer a tool for safety. It's a wall, a barrier between power and consequence. And the more that wall is used, the more fragile the law begins to look. So maybe the question isn't, should we end diplomatic immunity? Maybe it's, how do we make it honest? Because protection is not the same as permission. And the law, if it wants to keep its shape, must know the difference. Let's look closer at what gets lost. When a diplomat's actions harm someone, and the case is closed with 2 words, immunity applies. The damage spreads wider than the incident. It tells the public that justice can be paused, that the truth might matter less than titles. This silence creates distance between people and the system that's meant to protect them, between what's right and what's allowed. It sends a message, not loudly, but steadily. If you are important enough, the rules bend for you. And people hear that message. Victims withdraw. Communities lose faith. Police officers grow frustrated. Prosecutors feel powerless. And slowly, quietly, justice stops feeling like a path and starts feeling like a performance. Some countries have tried to reform. In the United Kingdom, certain diplomats must now register their immunity in a more transparent way. In the United States, repeat offenders have faced diplomatic sanctions. In Canada, law enforcement agencies are instructed to log incidents, even when they can't prosecute, so there is at least a record. But these are small moves in a system built on silence. Because ultimately, diplomatic immunity still depends on diplomacy. If a home country won't waive immunity, no further steps can be taken. The decision isn't legal, it's political. And political decisions often protect relationships, not people. This is where the discomfort grows. Because we like to think of justice as impartial, as a process that doesn't care who you are. But immunity proves otherwise. It shows that justice sometimes pauses, not for the facts, but for the flags. And that pause, while lawful, is rarely healing. So what should be done? Some have called for tiered immunity, a model where immunity protects diplomats from political interference, but not from criminal acts. Others suggest real-time waivers, an automatic review when serious harm is caused. But reforms move slowly. And in the meantime, the shield remains. So maybe the shift has to come from honesty. Honesty that says, yes, this rule exists, but it carries a cost. And that cost is paid by victims who never see justice. And honesty, too, from countries that use the shield, to recognize that immunity isn't impunity, to admit that waiving protection, when harm is real, is not a loss of face, but a sign of moral strength. Because every time immunity is misused, it loses a little more of the credibility it was built to protect. And if we want people to trust diplomacy, we have to show that it doesn't hide behind silence. It listens. It responds. It respects the law it expects others to follow. Let's return to the moment, the flashing lights, the quiet card, the decision not to pursue. It's a small scene, but it carries weight. Because every time a system steps back from justice, the public steps back from trust. Every time a crime is ignored, a victim learns that some pain is considered less important. Every time immunity is used to protect the powerful, it leaves someone else unprotected. This isn't an argument for removing every safeguard. Diplomacy matters. Protection matters. But accountability matters too. And if the system can't offer legal justice, it should offer something. Transparency, apology, support, a record, a voice. Because silence is not neutral. It's a message. And the message matters. When people see that justice sometimes stops at a passport, they don't just lose faith in the case. They lose faith in the law. So maybe the path forward is this. Keep the shield, but lighten its shadow. Make it clear that protection is not an escape. That respect for diplomacy includes respect for the people impacted by it. That immunity, when used well, is temporary, conditional, earned, and that no one, not even a diplomat, should live above the principles they represent. Because justice, to be real, must not only protect the powerful, it must reassure the powerless that they are not invisible. Even when the system has to step back, someone should still step forward and say, "We saw what happened, and it mattered." When corporations commit crimes, giving legal personhood to things that aren't human, the company was fined, its stock dropped, executives resigned, but no one went to jail. No one stood in court as a person accused of wrongdoing, because legally, the company itself was the person. This is legal personhood. The idea that a corporation, an organization, a structure can be treated like an individual under the law. It can own property, sign contracts, sue and be sued, even be held responsible for harm. But here's the paradox. A corporation is not a person. It doesn't think. It doesn't feel. It doesn't bleed. And yet, when crimes are committed in its name, it becomes the defendant, not the people who made the decisions, but the structure they built. Let's stay with this. Let's unpack what it means to treat an entity like a human, and what gets lost when responsibility becomes a legal fiction. Let's begin with the origin. Legal personhood was created to make the system work. You can't take a company to court unless you give it some kind of identity. So the law gave corporations certain rights. It allowed them to exist on paper like people exist in life. They could be sued. They could own things. They could be taxed. This made business easier. It made contracts smoother. It made liability clearer. But over time, something shifted. What began as a legal tool became something else, a shield. When a company is treated like a person, the real people inside it often step back. Decisions are made, harms occur, and when the fallout comes, it's not a person who answers. It's the entity. And entities don't feel shame. Let's say a pharmaceutical company hides data about side effects. People are harmed. The company pays a fine, maybe billions. But the executives who approve the decision, often, they walk away. They keep their jobs, or they retire comfortably, because the company takes the blame. And this creates a strange imbalance. Real people suffer. Real damage is done. But responsibility dissolves into something abstract. A name, a logo, a balance sheet. This isn't about one case. It's about a pattern. Banks launder money. Oil companies spill into oceans. Tech giants exploit data. And again, the answer is, the company will pay. But what does that mean? Fines are budgeted. Settlements are planned. PR teams write apologies. But the individuals who knew, who approved, who looked away, they rarely face criminal charges. Because the company is the person, and the person is too large to jail. This is where the logic begins to break. Because corporations don't make decisions. People do. And when the structure takes the fall, it allows those people to stay hidden. Now pause. This isn't a call for chaos. Companies need legal standing. Otherwise, modern economies wouldn't function. But legal standing is not the same as moral standing. And when personhood is granted without personal accountability, the law begins to lose its grip on justice. Because justice is meant to reach the source, not just the surface. Let's go deeper. When corporations commit crimes, they're often charged under laws that were never meant for humans. Corporate negligence, violation of regulations. The language stays cold, clean, controlled. But what's behind those charges is often very human: greed, pressure, calculation. And what's behind the company is often someone with a name, a desk, and a chain of emails. So why does the law look the other way? Partly, it's scale. Proving individual guilt inside a complex organization is hard. The decisions are distributed. The lines are blurred. That's how corporations are built, to spread responsibility thin. And partly, it's power. Corporations fund campaigns, hire lobbyists, sponsor events. They're too integrated to push too hard. So the system opts for what feels possible: large fines, public statements, quiet deals. But the problem doesn't go away. It repeats, grows, becomes normal. And that's the danger. Because when the law pretends that a company is a person, it gives that company the rights of a person, but not the soul of one. And without a soul, there's no remorse, just risk analysis. Let's step back and look at what this means for the average person. When you commit a crime, the consequences are direct. Your name, your body, your future. But when a corporation commits a crime, the consequences are often financial. And those costs, fines, settlements, compliance measures, are passed down to consumers, to workers, to shareholders. The people who felt the pain are not always the ones who caused it. This makes accountability feel hollow. And when accountability feels hollow, trust breaks down. People stop believing that justice is for everyone. They start to think it's for individuals without power, but not for institutions with it. And slowly, something shifts. The law becomes a tool for managing outcomes, not for reflecting values. A way to contain damage, not to confront it. A way to end the story quickly, not to learn from it slowly. And this silence speaks loudly, because legal personhood should have come with legal conscience. Instead, it often comes with legal insulation. So what's the solution? Some argue that we need stronger individual accountability, that when executives knowingly approve illegal behavior, they should face personal charges, not as an example, but as a reflection of the truth, that decisions are made by people, not papers. Others suggest limits on corporate personhood itself. Maybe entities can have some rights, but not all. Maybe they shouldn't be able to donate to campaigns. Maybe they shouldn't have the same free speech rights. Maybe their role in public life should reflect their structure, not their legal fiction. Still others push for transparency, for stronger whistleblower protections, for clear chains of command, so that when harm occurs, we can trace it, not vaguely, but precisely. And then there are those who say, make the fines hurt more, make them scale to impact, make them unignorable. But even that has limits, because money, for many corporations, is not a deterrent. It's a cost of doing business. And morality doesn't live in spreadsheets. So maybe the real shift begins not with law, but with story, with how we talk about corporations, with refusing to call them people when it lets real people hide, with naming those responsible, with understanding that a logo is not a shield, and that justice must be aimed at the hands that held the wheel. Because if the law keeps treating organizations like persons, it has to remember what personhood means. It means choice, consequence, accountability, not just for the entity, but for those who built it. Let's return to the courtroom. A settlement is announced. A press release is issued. A fine is paid. And somewhere, behind all of it, sit the people who made the decision untouched. The company takes the fall. The people step back. This is the quiet trade-off of corporate personhood. It offers order, but at a cost. Because when no one stands up and says, "I was responsible," the harm lingers. It doesn't close. It just moves. Downward, outward, into communities, into families, into faith in the system. And the law, which is meant to bring balance, begins to tilt. This doesn't mean every executive is guilty, or that every case has a villain, but it does mean the system should look deeper, should ask harder questions, should not settle for structure when the answer lies in intent. Because companies don't act, people do. And when the law forgets that, it forgets why it exists. So maybe the future looks like this: legal personhood, yes, but with human consequences, rights for corporations, but also responsibilities, structures that protect, not deflect. Because justice, to be real, must move toward the source, not the logo, not the building, but the decision, and the one who made it. Only then does the law speak clearly, not with settlements, but with truth. And only then does accountability feel real, not to the company, but to the people it serves, and sometimes the people it harms. Trapped by the system, the Mandela rule. When you're innocent, but still legally locked away. He was innocent, not just believed to be. Proven, cleared, exonerated. The evidence showed he didn't do it, but he remained behind bars. Why? Because the process wasn't finished. Because appeals take time. Because release requires signatures, hearings, final steps. And until all that is done, the law keeps him there. This is the quiet cruelty of the system. You can be declared innocent and still be trapped. The Mandela rule, adopted by the UN, says that prisoners must be treated with dignity, that no one should be subject to torture or degrading treatment. But what do you call keeping someone locked away after they've been proven innocent? It's not punishment. It's not justice. It's something else. Let's sit with this. Let's look at how a system meant to protect can sometimes imprison, even after the truth is known. Let's start with the reality. The legal system is not fast. It's deliberate. It moves through steps, each one documented, each one bound by procedure. That's part of what keeps it fair, but it's also what makes it slow. And slowness, in this context, becomes something worse. Imagine being told the court agrees you're innocent, that your conviction has been overturned, that you should be free, but your cell doesn't open. Your meals still come through a slot. Guards still count you. Days still pass. Because the paperwork isn't done. This isn't theory. It happens. People who've had charges dropped. People who've been exonerated by new DNA evidence. People who've had their witnesses recant. Still sitting in a cell. Waiting. Sometimes for weeks. Sometimes for months. Why? Because the system wasn't built to move quickly when it admits it's wrong. It knows how to prosecute, how to convict, how to sentence, but it doesn't know how to undo, how to unlabel someone, how to unmark them in the system. So it keeps them where they are, not because of guilt, but because of inertia. This is where the Mandela rule meets reality. The Mandela rules are guidelines, named after Nelson Mandela, for how prisoners should be treated. They're about human dignity, clean water, light, communication, mental health. They're about saying, just because someone is behind bars doesn't mean they stop being a person. But what happens when the person isn't supposed to be behind bars at all? What do we call a delay that keeps an innocent person locked in a cage? Is it a mistake, a flaw, or is it something closer to abandonment? Because the system doesn't mean to harm, but its structure does. And intent isn't always what matters. Impact is. And the impact here is deep. People who are cleared, who are proven innocent, often describe this time, the time after innocence, as the hardest. Harder than trial. Harder than prison. Because they've crossed the line. They've reached freedom. But the door doesn't open. And that break, That moment of being held by a system that no longer believes you belong there does something to the mind. It tells you, even truth doesn't matter fast enough. And that's a wound that doesn't heal with release. Let's go further. Sometimes, the system says a person is no longer guilty, but it doesn't say they're innocent. Charges are dropped without prejudice. A conviction is overturned, but not erased. And that gray space, that legal in-between, keeps people in a cage of ambiguity. They're not guilty, but they're not free either. This creates a strange purgatory. You wait for courts to clear your name more officially. You wait for paperwork to catch up with the truth. You wait for someone, somewhere, to process the fact that you don't belong where you are. And that wait is not neutral. It's filled with quiet harm. The world outside moves on. Friends forget. Employers don't call back. The media never prints the follow-up. And the system that failed you now tells you to be patient, as though patience undoes injustice. Let's name it plainly. This isn't just a delay. It's a second sentence. A sentence served for the crime of being inside the system at all. And it happens more often than most people know. Take the case of Anthony Wright, convicted of a brutal crime in Philadelphia. DNA later proved he was innocent, but the process to release him dragged on. Motions, reviews, delays. He spent extra time in a place that no longer had a right to hold him. Or Khalif Browder, accused at 16, never convicted, never tried, spent over 3 years in jail, most in solitary confinement, because the system kept postponing. He was innocent in the eyes of the law, but the law kept him anyway. These stories aren't rare. They're just rarely told, because the system isn't built to apologize. It's built to process, to manage, to keep moving. And when someone is caught in its gears, even after innocence, they're often told, wait your turn. But innocence isn't something that should wait. Freedom delayed is not neutral. It's violence by bureaucracy, pain measured in paperwork. So what should change? Some say we need a formal mechanism, an automatic release when innocence is proven, a legal switch that flips the moment a conviction is voided. Others call for deadlines. If someone is cleared, the system should have hours, not weeks, to act. And if it doesn't, those responsible for the delay should be accountable. Because without consequence, delay becomes routine, and routine becomes the next injustice. Let's return to the cell. The court has spoken. The evidence is clear. The person inside knows they've been proven right, and yet the door stays closed. It's not dramatic. It's quiet. A slow-motion injustice. Guards still walk by. Lights still turn off at night. Meals still come on trays. And outside, the world assumes that everything has been fixed. But inside, time doesn't wait. This is the truth behind the Mandela rule. That dignity doesn't begin when the system is ready. It begins the moment the system realizes it's wrong. So what would real justice look like? Maybe it starts with urgency. With systems designed not just to convict quickly, but to release quickly too. With resources set aside for speed, not just for punishment, but for repair. Maybe it starts with transparency, with tracking every innocent person still inside, with counting those hours, with asking why. And maybe it starts with a shift in belief, that innocence is not something the system gives. It's something it must honor, immediately. Without hesitation, because every extra hour in a cell for someone who doesn't belong there isn't just a delay. It's a theft of time, of peace, of trust. And if the law wants to call itself just, it must learn to let go as quickly as it holds on. Justice doesn't end with truth. It ends with freedom. And freedom should not have to wait for paperwork. Double Jeopardy and the game of loopholes. How someone guilty can't be retried, even if new proof appears. The jury said not guilty. The man walked free. But a year later, new evidence appeared, video, fingerprints, a confession, proof. This time, that he did it. But he can't be retried. not in the same court, not for the same crime, because the law says one trial is enough. This is double jeopardy, a rule meant to protect the innocent from being prosecuted again and again, a safeguard against the state's power. But sometimes, it protects the guilty too. It's not a flaw in the system. It's part of its design. And that design raises a hard question. When truth comes late, what do we value more, finality or justice? Let's sit with this. Let's unpack how a law meant to prevent abuse can sometimes feel like a locked door, even when the truth is knocking. Let's start with the principle. Double jeopardy means you can't be tried twice for the same crime. Once a verdict is given, guilty or not guilty, the case is closed. The government can't keep bringing you back into court, hoping for a different outcome. This protects people from harassment, from being worn down by the weight of the state. And most of the time, it works. It brings peace to those falsely accused. It stops abuse. It reminds us that justice must have limits. But the rule is absolute. And that's where the tension lives. Because sometimes, new evidence changes everything. A confession from someone who finally speaks. DNA results that weren't available before. A witness who lied and then recants. Technology that sees what older tools missed. And suddenly, the story is different, clearer, sharper. But the door to justice is already closed. The person who committed the crime can't be tried again. Not because they're innocent, but because the law says it's over. This isn't a loophole. It's a wall. And that wall was built for good reason. In history, states have retried people endlessly, kept them in court until they broke, used the legal system not as a tool, but as a weapon. Double jeopardy says, one shot, one decision, one end. It forces the state to do its job well the first time, to bring its best case, to respect the weight of a verdict. But when the first case fails, when the truth shows up later, the rule starts to feel less like protection and more like paralysis. And people watching wonder, how can this be right? Let's walk through an example. Someone is charged with murder. The case is weak, circumstantial. The jury acquits. Years pass. Then video is found. Clear, undeniable. But nothing can be done, because the system isn't built to reopen. It's built to move forward. And this raises the hardest question. Should we change it? Some countries have. In the UK, reforms now allow a second trial if new and compelling evidence appears in serious cases. It's rare, carefully used, but it's there. A small door, opened by truth. In other places, the rule remains absolute, sacred, untouched, and the debate continues. Because what we're really asking is, which matters more, certainty or flexibility? Certainty says people should know when they're safe, that after a trial, their life can go on. Flexibility says justice should keep moving when truth arrives. But both come with risk. Remove double jeopardy, and we risk abuse, endless retrials, political persecution, fear. Keep it unchanged, and we risk letting truth stay powerless. Harm unanswered, crimes forgiven by silence. So how do we choose? Let's shift the focus to emotion. For victims and their families, double jeopardy can feel like a second wound. First, the pain of loss. Then, the trial. Then the verdict, not guilty. And then, the silence. Even if new evidence surfaces, the system doesn't move. They're told to accept the outcome, to move on. But how do you move on when you now know who did it? And the law tells you that knowledge is irrelevant. There's a kind of grief that comes with knowing the truth too late. It doesn't come with rage. It comes with fatigue, with a slow, grinding disbelief that truth can lose, not because it's wrong, but because it arrived after the deadline. And that deadline isn't emotional. It's procedural, paperwork, precedent, principle. That's what makes this so hard. Because double jeopardy isn't protecting a person. It's protecting a structure, a rule, a framework, and rules. even good ones, can cause harm when they become unbendable. The same is true on the other side. Without double jeopardy, the state could retry cases endlessly. A not guilty verdict wouldn't be the end. It would be the beginning of a waiting game, waiting until a more favorable judge, a better jury, a more convincing presentation. It would turn innocence into a temporary condition. This is why the rule exists, to prevent fear from becoming permanent. But in between these two truths, one of safety, one of finality, is a third space, the space of the rare exception. Could we build a system that honors both sides, that keeps the core of double jeopardy but allows a narrow, guarded path for revisiting serious cases when new, irrefutable evidence appears, not as a loophole, but as a correction, one bound by strict rules, one that protects the accused but listens to new facts, one that doesn't see truth as a threat, but as a reason to look again. This isn't about undermining verdicts. It's about confronting the rare moments when the verdict missed something essential, moments when a system designed for truth is asked to ignore it. And the cost of that silence isn't just legal. It's cultural, because when people believe that truth can lose to timing, they lose trust. And when they lose trust, they stop believing justice can change anything. That's a cost we can't ignore. Let's return to the courtroom, not during the trial, but after, when the chairs are empty, when the verdict has been read, when justice, for better or worse, has been declared done, and then weeks, months, or years later, truth arrives. It knocks. It waits. But the door doesn't open, because the rule says no. This is not a failure of law. It's a failure of imagination, of building a system that can hear new truth, but feels powerless to act on it. So what can be done? Maybe the answer is narrow exceptions, carefully designed. Maybe it's an independent body that reviews cases only when new, overwhelming evidence appears. Maybe it's a one-time window, where the state must act within days, not months, to request a second trial. Maybe it's all of these. But whatever the shape, the spirit must remain clear, to honor truth without eroding fairness. Because fairness is not rigidity. Fairness is balance. It's the ability to protect the innocent and still listen when the story changes. And justice, if it's to mean anything, must be strong enough to correct itself. We don't need a system that never changes. We need one that knows when it should. So let double jeopardy stand. But don't let it become deafness. Because truth doesn't always arrive on time. And when it does show up, late and breathless, it still deserves to be heard. The stand your ground loophole. When you can kill legally just by saying you felt threatened. He pulled the trigger. Someone died. But when the police arrived, he said just one thing. I felt threatened. And that was enough. No arrest. No charges. Because in some states, that feeling, if considered reasonable, is all it takes to justify deadly force. This is the stand your ground law, a legal defense that removes the duty to retreat. It says that if you feel in danger, you can act immediately and with force, even if you had another option. But what counts as danger? And who decides what fear looks like? Let's sit with this. Let's unpack how a law designed for self-defense can quietly become a license for something else, and why the difference between fear and justification is harder to draw than we want to admit. Let's begin with the intention. Stand your ground laws were meant to empower people to defend themselves, to remove the expectation that, when threatened, you should first try to flee. Instead, they say, if you're somewhere you have a legal right to be, and you feel your life is in danger, you can defend yourself, even with deadly force. In principle, it sounds like clarity, like protection, but in practice, it's more complicated, because fear is not objective. It's emotional. It's shaped by experience, by bias, by instinct. And when the law treats fear as enough, it gives that emotion legal power. A person can kill, claim they were scared, and walk away, No weapon found on the other person. No evidence they were about to attack. Just a feeling, if the court deems it reasonable. This is where the loophole begins. Because what's reasonable is hard to define. It depends on who's asking, on the jury, on the judge, on the culture. And history shows us, not all fear is treated equally. Some people are more easily believed. Others are not. Fear is judged through the lens of race, class, gender. A man may feel threatened by another man simply because of how he looks, how he moves, where he stands. And if that fear is accepted, it becomes justification. This isn't theoretical. Cases have shown this again and again. Unarmed individuals shot in parking lots, killed over loud music, over mistaken gestures, over perceived confrontations. And when the shooter says, "I felt threatened," the law listens, and the person who died, they don't get to explain their side, their fear, their experience. Because stand your ground, laws don't ask what the other person felt, only the shooter. And that imbalance is quiet, but deep. It tells us that fear is a defense if you survive. But if you don't, your fear is erased. That's not balance. It's asymmetry. And in the hands of those who already feel empowered, it becomes something else, permission. Not to kill without consequence, but to shape the consequence in advance. To prepare the story. To anchor the narrative around the one who felt danger, not the one who faced it. And in a country where perception is shaped by centuries of bias, that becomes dangerous. Because now, fear isn't just a feeling. It's a strategy. A way to explain what shouldn't be excusable. A way to say, "I didn't mean to kill. I just meant to feel safe." And the law nods. And the charges drop. And the headlines pass. And someone is gone. Let's go deeper. Imagine standing in a space that's legally yours. A driveway, a street, a store. Someone approaches. Maybe their voice is raised. Maybe they gesture. You misread it. You think they're going to hurt you. You shoot. They fall. You call it self-defense. But what if they were reaching for their phone? What if they were backing away? What if they were afraid of you? These are not rare questions. They're at the center of real cases. Because stand your ground removes the filter of de-escalation. It skips the pause. It erases the question. Could I have done anything else? The law doesn't ask you to retreat. It doesn't ask you to speak. It doesn't ask you to assess, only to feel. And feelings, under pressure, are not reliable. Fear is a fast emotion. It doesn't process details. It reacts. And when fear is given the power to justify a killing, the threshold for what counts as reasonable becomes dangerously low. What counts as reasonable fear? A sudden movement? A stare? A stranger in the wrong place at the wrong time? Courts try to draw that line. But the line is slippery. It moves with culture. It bends with perception. And perception is shaped by something we don't always want to admit: prejudice. That's why critics argue that stand your ground laws have two faces. In theory, they apply to everyone. In practice, they often favor those who fit the image of fear, not those who live with it. People of color are more likely to be seen as threatening, more likely to be shot, less likely to successfully claim the same defense. The law is written neutrally, but it operates in a world that isn't. This makes the loophole not just legal, but cultural. Because when a system says your fear is more important than their life, and that fear is shaped by bias, it stops being justice. It becomes license. Not in every case, not for everyone, but often enough to erode trust. And trust, once lost, is hard to restore, especially when the pattern becomes visible. When communities see the same defense used again and again. When families watch their loved ones reduced to a headline and a justification. Especially when the law seems to care more about the right to feel afraid than the right to exist. So the question becomes, what should change? Some say repeal the law. Restore the duty to retreat. Say clearly that self-defense is not the same as escalation. Others argue for stricter definitions. Make fear provable. Make justification harder to claim. Require evidence, not just emotion. Others focus on training. Teach people to read situations better, to assess before reacting, to understand that protection isn't always about power, it's about clarity. But all of these share one goal: to ensure that feeling afraid isn't enough to take a life. Because fear, unchecked, can be deadly. And when it's backed by law, it doesn't just end one life, it teaches others how to do the same. Let's come back to the moment, the one that's so often described in court. I felt threatened. Those 3 words don't just explain an action. They build a frame, a lens through which everything is reinterpreted. The body on the ground, the absence of a weapon, the questions that follow. But sometimes, what feels like fear is actually discomfort. Sometimes, what feels like danger is difference. And when discomfort is treated like a threat, the space for compassion shrinks. This is what makes the loophole so dangerous. It tells people that feeling unsafe is the same as being unsafe. It encourages reaction over reflection. It replaces understanding with instinct, and instinct, like fear, is shaped by history. So what should we demand from the law? Maybe not perfection, but presence. A law that sees the difference between defense and preemption. A law that understands the gravity of a decision to end a life. A law that requires more than just fear, it requires fact. Because when fear becomes the only justification, we lose something essential. We lose the chance to ask, what really happened? We lose the time to ask, could it have gone differently? And most of all, we lose the people who never got the chance to explain why they were afraid too. Let the law protect the right to safety, but not at the cost of silence, not at the cost of reflection, and never at the cost of truth. Because real justice doesn't begin and end with fear. It begins with asking more. The right to remain silent unless you speak. Why anything you say and don't say can hurt you in court. They told him he had the right to remain silent. So he stayed quiet. He waited for a lawyer. He didn't speak. But later, in court, the prosecutor asked, why didn't he deny it then? If he's innocent? And suddenly, that silence, the one the Constitution promised was his right, was turned against him. This is the paradox of silence. The right that protects you can also raise suspicion. And in some cases, your decision not to speak becomes part of the evidence. It's not always what you say. Sometimes, it's what you don't say that changes everything. Let's sit with this. Let's explore how silence, meant to guard you, can be reinterpreted, repurposed, and used as a quiet weapon in a courtroom. Let's begin with the promise. In many countries, especially the United States, you're told at the moment of arrest, you have the right to remain silent. It's meant to be a shield, to protect you from saying something under pressure, to give you space, to keep your words from being twisted. But silence is not always neutral. And in court, it can echo louder than you think. There's a difference between staying silent before arrest and staying silent after. That line matters, because before arrest, your silence can sometimes be used to suggest guilt. Courts have ruled that if you weren't yet in custody, and you chose not to respond, your silence might look suspicious, even after arrest. If you don't clearly say you're invoking your right, just staying quiet can still be questioned. Jurors may wonder, why didn't they speak up? Why didn't they say something if they were innocent? The right is there, but it's not automatic. It must be declared. And once you start talking, even a little, the protection weakens. This is the trap, because the human instinct is to explain, to defend, to clarify, especially when accused. Silence doesn't feel like safety, it feels like guilt. And people often speak without knowing the consequences. But if you speak, even a little, that partial silence, what you didn't say, can now be examined. Why mention this detail and not that one? Why explain one thing but not another? And suddenly, your silence becomes a puzzle piece. something for lawyers to point to, something to shape a narrative around. This is what makes the right to silence so fragile. It exists, but it's surrounded by conditions. You have to know it. You have to claim it. You have to keep it. And if you don't follow every rule, your silence might speak louder than you ever meant it to. Let's sit with the psychology. Most people believe that if they're innocent, they should explain, clarify, deny. And so when someone says nothing, jurors wonder, what are they hiding? But that belief ignores the reality of fear. People stay silent for many reasons: shock, confusion, mistrust, trauma. Silence is not always strategy. Sometimes it's survival. And when the law treats that silence as suspicious, it forgets what silence actually is: a pause, a breath, a space before speech. Not proof, not guilt, just space. But courtrooms are not always built for nuance. They're built for argument, for storytelling, and silence, in the hands of a prosecutor, becomes a thread to pull, a signal to interpret, a moment to question. And so the very thing designed to protect a person becomes the thing used to undo them. That's the contradiction. And it's a quiet one. Let's look at how this plays out in real life. Imagine someone accused of a serious crime. They're shocked, confused. They say nothing, not because they're guilty, but because they don't understand what's happening. Later, in court, the silence becomes a focal point. They didn't deny it when they had the chance. But what chance? The moment of silence wasn't strategic. It was instinct. But in the courtroom, instincts don't always carry weight. This is where the legal structure meets human behavior and often misinterprets it, because silence is complex. Some people go quiet under stress. Others were taught to distrust authority. Some just freeze. And yet the system often interprets silence as clarity, as guilt, as something deliberate. This isn't how justice should work. The legal right to remain silent should be absolute. It should not depend on whether the accused used the right magic words to invoke it. It should not depend on timing, context, or interpretation. But in practice, it does. And this creates uncertainty, especially for the poor, the uneducated, the mentally ill, for people who don't know that silence is a right that must be claimed, for those who assume staying quiet protects them, only to find it didn't. This is how silence becomes a trap. Even after invoking the right, people are often pressured to speak. Police continue to ask. Prosecutors imply that cooperation means innocence. And jurors, ordinary people, often expect that if someone is innocent, they would speak up. They forget that silence is not avoidance. It is protection, and that the system itself tells you to be silent for your own safety. So what happens when that silence is used against you? You feel betrayed, not just by the accusation, but by the rules that were meant to protect you. You did what the law told you to do. And still, it became evidence. Still, it raised questions. That's not just confusing. It's destabilizing. Because silence is supposed to be neutral, a space to breathe, a right that's clear and consistent. But instead, it becomes a gamble. So what can be done? Some argue for stronger legal protections, that no silence before or after arrest should be interpreted as evidence of guilt, that jurors should be clearly instructed that silence is not suspicious, that the right to remain silent should mean exactly that, without condition, without loopholes. Others call for better education, for people to know that silence must be declared and maintained, that once you speak, the protection fades, that you have to say the words, "I am invoking my right to remain silent." And even then, it might still be questioned. That's the deeper discomfort. Because when a right exists only in theory, but not in practice, it stops being a right. It becomes a suggestion, a guideline, a hope. And hope is not enough when your freedom is on the line. Let's return to the moment, the one where the accused stays silent. Maybe they're waiting for a lawyer. Maybe they're in shock. Maybe they believe the system works. And maybe, just maybe, they trust that their silence will be respected. But then, in court, it's reframed, questioned, pulled apart. That silence, once protective, is now painted as a decision, a sign, a tactic, and the right to remain silent begins to feel like a trick. This is the quiet danger, because rights must not only exist, they must be honored, they must be consistent, they must protect people who don't speak the language of law, people who are scared, people who don't know the script. So maybe we need to say this clearly, and mean it. Silence is not guilt. Silence is not a story. Silence is not a lie. Silence is a right. And a system that respects that right should never use it as a weapon. It should hold it gently, guard it carefully, because in that silence lives something sacred, the space between accusation and explanation, the moment before a person speaks, the breath before a life changes. Let that space be safe. Let that silence mean exactly what the law says it should mean. Nothing. No body. No crime. Can someone be convicted of murder with no corpse? She vanished. No one saw her again. No body was found. No weapon. No confession. Just a trail of suspicion and someone who had motive, opportunity, and something to hide. But was that enough? This is the question at the heart of one of the oldest legal puzzles. Can someone be convicted of murder if there's no body? Traditionally, the answer leaned toward no. Without a body, there was always doubt. Maybe the person was missing. Maybe they ran. Maybe they weren't dead at all. But over time, the courts have evolved, because disappearance doesn't mean survival. And sometimes, absence is the most powerful evidence of all. Let's sit with this. Let's explore how a system that relies on proof decides guilt when the clearest proof of all, a body, is gone. Let's begin with the traditional logic. For centuries, the legal system hesitated to convict without a body. It made sense. A body is proof. Proof that a crime happened. Proof that someone died. Without it, everything else feels less certain. Because murder is not just about motive. It's about result. And without a body, can we truly say a result occurred? That question kept many suspects from being charged. Prosecutors were wary. Juries were uncertain. And the defense only had to suggest one thing. Maybe she's still alive. That single doubt could undo everything. But over time, the justice system started to change. Cases emerged where the body was never found, but the evidence was overwhelming. Bloodstains that couldn't be explained. Personal items left behind. Search histories that revealed intent. Witnesses who saw just enough. Technology helped too. DNA could confirm presence. Digital trails could map movements. Phone records, texts, deleted messages, all became part of the narrative. And when that narrative was tight, a body wasn't always necessary. Courts began to accept what used to be unthinkable. That absence, when paired with pattern, could prove presence of guilt. Still, these cases are rare, and for good reason, because convicting someone of murder with no body carries weight. If you're wrong, there's no going back. And if the missing person turns up alive, the system doesn't just fail, it collapses. That's why these trials are cautious. The standard remains high. The burden doesn't shift. Prosecutors must still prove, beyond a reasonable doubt, that a death occurred and that the accused caused it. Not easy, but not impossible. The law now recognizes something it once resisted, that a body is not the only way to know someone is gone. Sometimes, their silence is louder than a scream, their absence more permanent than any wound. And when someone vanishes completely, leaves behind their life, their home, their child, their paycheck, without a trace or a reason, it begins to look less like a mystery and more like a plan. Let's consider the psychology. When someone commits murder and hides the body, they're not just trying to avoid punishment. They're trying to erase the event, to remove the proof, to delay the moment when suspicion becomes charge. But hiding the body is also a clue. It reveals intent, fear, guilt. It shows that the killer knew what they did and wanted to unwrite it. So in cases with no body, the prosecution often focuses there, on behavior after the disappearance, on stories that change, on panic, on cover-ups, on the question, if you're innocent, why do you act like someone who's not? And juries listen, because while the body may be gone, the pattern of guilt often remains. Let's look closer at how these trials unfold. A person disappears. The police search. No body, but the patterns begin. There's no contact, no activity on credit cards, no phone calls, no social media, not even a passport scan. Time passes, and nothing changes. That silence grows louder, and the investigation shifts from rescue to recovery, from missing to presumed dead. But presumed is not proof. So the system builds a case not on a single clear moment, but on 1,000 small ones. Inconsistencies in the suspect's timeline, strange purchases, deleted messages, a fight overheard, a motive that simmers just below the surface. In a no-body trial, everything matters. Every gap in the story, every hesitation in the interview, every choice made after the disappearance. Because the prosecution isn't just proving what happened. They're proving that something happened, and that this person knows why. And that's what makes these cases so difficult. They demand that the jury believe in absence, that they accept the silence as final, that they trust the evidence even when the most basic evidence, a body, is missing. It's a heavy burden, and yet, it's not impossible, because sometimes, the person who disappeared would never have left without saying goodbye, would never have left their child, would never have walked away from a mortgage, a job, a life. And that's what convinces the jury. Not just science, but story. The story of a person who had no reason to vanish until someone gave them one. Let's shift to the emotional impact. For families, no-body cases are brutal. There's no grave, no closure, no final moment, only questions, the kind that echo for years, that follow you into sleep, that wait in every voicemail, every knock at the door. And if there's a trial, the courtroom becomes a battlefield between absence and certainty. The defense only has to ask, where's the proof she's dead? And for a grieving family, that question can feel like violence. But the law allows it, because justice must be thorough. And fairness means even the unbearable must be spoken. Still, when a conviction is reached, something settles. Not everything, but something. Because even without a body, the truth can still be heard. Not just through what's present, but through what never returned. And the system, slowly, carefully, learns to listen to what isn't there. Let's return to the question. Can someone be convicted of murder without a body? Yes, but not easily, not lightly, because conviction without a corpse is not just a legal test, it's an emotional one. It asks everyone in the room to believe in something they cannot see, to accept that some disappearances are final, even when there's no grave, and that belief must be earned. The law demands more in these cases, more evidence, more certainty, more coherence, not because doubt is wrong, but because the consequences are permanent. So when a jury says guilty in a no-body trial, it means something powerful. It means they saw the truth in the silence. They followed the trail of absence. They heard the shape of guilt in the things unsaid. And they understood that justice, while built on proof, is not blind to pattern, because sometimes the absence of a body is the strongest evidence of all. And sometimes, the body isn't the proof. The behavior is. Suing the dead or being sued while dead. Legal cases that continue even after someone dies. He was gone, buried, mourned. The world had moved on, but the courtroom hadn't. A trial was still scheduled. A lawsuit was still active. His name was still on the docket. Because in the eyes of the law, death doesn't always end responsibility. Sometimes, the dead can be sued. And sometimes, lawsuits filed before death continue long after the person is buried. In other cases, the deceased can even remain a defendant in a criminal appeal, or still owe damages in civil court. This is one of the quietest legal paradoxes. What happens when justice outlives the person? Let's explore what it means for a system to keep going after its subject is gone, and how courts navigate the strange, surreal territory of litigating against the dead. Let's begin with civil cases. When someone dies, they don't take their debts with them. If they owed money, if they caused harm, if a lawsuit was already in motion, the legal process often continues. Not against them directly, but against their estate. The estate becomes the defendant, a legal stand-in. It includes whatever they left behind: property, bank accounts, investments. The law treats that estate like a legal body, even though the person is gone. This isn't about punishment. It's about resolution, because the law doesn't want someone's death to erase their impact. If a person harmed someone, stole from someone, or breached a contract, their death doesn't mean that harm vanishes. It means someone else, the heirs, the executor, must answer for it. This can feel strange, even cold. Families grieving a loss now face legal papers. Executors not only divide assets, they defend reputations. Courtrooms speak of the deceased in the present tense, long after the funeral. But the system sees it differently. It sees a person's legal presence as lasting beyond life, until their affairs are settled, until their debts are closed. And in some cases, that's not just financial. Reputation is at stake too. If someone was being sued for defamation, abuse, negligence, even death doesn't always end the case. Plaintiffs may continue the suit. They want truth, public record, a ruling that says, this happened, and courts allow it, because some things must be answered, even if the person who could answer them no longer can. Let's move to criminal law. In most cases, criminal charges die with the defendant. The state can't punish the dead. There's no point in sentencing someone who's no longer alive. Trials are dismissed. Appeals stop, but not always. Sometimes, a conviction is still appealed after death, not by the state, but by the family, because even though the person is gone, the stain remains. A conviction sits on public record, and families want it erased. For history, for legacy. These are called posthumous exonerations. They're rare, but they matter, because sometimes the system got it wrong, and clearing a dead person's name becomes a way of acknowledging that mistake. And sometimes, more rarely, a criminal case continues even when death is known. Why? Because the law needs a ruling for civil reasons. Because there's insurance at stake, or benefits, or compensation that hinges on a guilty or not guilty outcome. So even though the defendant can't face jail, the court still moves forward. And that feels surreal, because justice is supposed to be personal, alive, immediate. But here, it becomes something else. A shadow trial. A process that no longer speaks to the person, but to the idea of the person. And still, the court proceeds. Let's pause and ask, why does this matter? Because it forces us to look at how the law sees a human being, not just as flesh and breath, but as a carrier of legal weight. A person's presence doesn't disappear with death, at least not entirely. Their name, their actions, their consequences remain, and the system can't, or won't, ignore that. This becomes especially complicated in high-profile cases. A celebrity dies while under investigation. Allegations remain unanswered. Victims want justice, but prosecutors must stop. The court, tied by rules, closes the file, and society is left with a question that may never be resolved. Or take financial crimes. A fraud case is halfway through trial. The defendant dies. Investors still want compensation. But how do you untangle personal guilt from corporate damage? The individual is gone, but the effects ripple out. So courts proceed, not to punish the dead, but to trace the consequences they left behind. In rare cases, the dead are even sued as a legal strategy. Sometimes, suing a dead person is the only way to access their estate, or the only way to make a record of harm. Plaintiffs know the person can't respond, but the suit makes the damage visible. It sets a marker. It puts their pain in the public record. And that matters, because the law isn't just about resolution. It's about memory. Lawsuits after death are not only about money. They're about dignity, about truth, about naming what happened, even when the person responsible can no longer hear it. And for the families of the deceased, it can cut both ways. Some feel violated, that the law won't let their loved one rest, that the dead are being dragged through a courtroom they cannot enter. Others feel vindicated, that reputation can still be cleared, that harm can still be answered, that the legal system didn't forget. This is where law intersects with grief. The courtroom becomes a strange mirror, one that reflects not only evidence, but mourning, memory, and meaning. The deceased is no longer there, but their echo is, and the system speaks to that echo formally, carefully, and with consequences. So what should the law do? It must be cautious, respectful, aware that death changes everything, even the purpose of justice. But it must also be brave enough to keep going when it's needed, when harm is real, when truth matters, when a decision, even after death, gives shape to the story. Because justice is not only about the living, it's about what the living remember. Let's return to the courtroom, quiet now. The defendant absent, the name still etched on the paperwork. There is no cross-examination, no chance to apologize, no last word, only documents, memories, and legal motions that speak in past tense. But justice does not always end with breath. Some stories outlive the body. Some wrongs still ask for recognition. And some rights, like clearing a name, still matter, even when the person they belong to is gone. So the law continues. It sues estates. It processes claims. It weighs evidence left behind. It balances dignity with duty. Because sometimes, a person's impact doesn't end with death. It continues in harm, in silence, or in memory. And the law, though slow and imperfect, tries to meet that continuation, not to punish, but to close the story, properly, not to forget, but to acknowledge, out loud, what the living already feel in their bones. That justice doesn't always arrive when someone is alive, but sometimes it still arrives. And that, too, is part of what it means to live under law. Crime without intent, strict liability laws. Going to jail for something you didn't mean to do. He didn't mean to do it. He didn't know it was illegal. There was no plan, no motive, no malice. But that didn't matter. He was arrested, charged, convicted. Because under strict liability laws, intention is irrelevant. This is one of the most unsettling features of the legal system. The idea that you can be found guilty of a crime even if you didn't know you were committing one, and even if you had no intent to cause harm. Let's pause here. Let's sit with the idea that justice can punish not what you meant, but simply what happened, and explore how these laws meant to protect sometimes do the opposite. Let's begin with what strict liability means. In most crimes, intent matters. The law wants to know what you were thinking, what you planned, what you knew. That's what separates a mistake from a crime. What was in your mind when it happened? But not here. Strict liability laws remove that layer. They focus entirely on the act itself. If you did it, even by accident, you're responsible. The law doesn't ask whether you meant to. It just asks whether it happened. This sounds harsh, and it can be, but the purpose behind it isn't cruelty. It's control. Strict liability laws usually apply to public welfare offenses, things like selling expired food, environmental violations, unlicensed construction, statutory rape, The idea is to hold people accountable for actions that put others at risk, even if those actions weren't intentional. In these cases, the law chooses safety over subjectivity. It draws a hard line and says, if this happened, someone must answer for it. But here's the cost. It means people can go to jail or face massive fines for mistakes, for oversights, for not knowing. And that changes how justice feels. Because when we think of justice, we imagine balance, fairness, proportion, and strict liability breaks that expectation. It says guilt isn't about intent. It's about result. You didn't check the label closely enough? You're guilty. You didn't realize the permit expired? You're guilty. You thought she was old enough, and she lied? You're guilty. There's no space in the law for context. No space for confusion. No space for I didn't know. And that's where the discomfort begins. Let's consider the emotional impact. Imagine being punished not for what you chose, but for what you failed to understand. Imagine explaining yourself, only to be told it doesn't matter, that the outcome is all that counts. That's what strict liability does. It reduces people to actions. It flattens complexity. It erases the human side of error. And while that may be efficient, it's not always just, because not all mistakes are created equal. Some come from carelessness, others from circumstance, some from genuine confusion. But under strict liability, those differences disappear, and the sentence arrives anyway. This is especially true in statutory rape laws. A 19-year-old sleeps with a 16-year-old who claimed to be older. There's no violence, no coercion, but the law says she was too young to consent, and that makes it a crime. His knowledge, his belief, his trust, legally, irrelevant. And that label, sex offender, doesn't go away. It follows for life. That's the weight of strict liability. It makes no room for gray. And yet, the world is gray. Let's consider why these laws exist in the first place. Lawmakers create strict liability rules when they believe the risk is too high to leave room for debate. Selling contaminated meat, polluting a water source, driving with faulty brakes. These are acts where harm could spread quickly, and proving intent would slow enforcement. So the system removes intent to prioritize prevention. To say, you're responsible for what you control, even if you didn't know something was wrong. And in some cases, that makes sense. A manufacturer is expected to ensure safety. A builder must check permits. A pharmacist must know what they dispense. These aren't casual errors. They're responsibilities, and strict liability helps enforce them. But not every case is so clear. Sometimes, the law treats an everyday misstep like a deliberate act. It punishes those who had no way to know, or tried to comply but failed. It catches the wrong people. And the weight of the punishment doesn't always match the nature of the error. This is where the human cost shows. Because when someone is convicted of a strict liability offense, they carry the full weight of guilt, but none of the intent. And for the public, the record doesn't show the difference. A label is a label. A crime is a crime. But the context, the difference between deliberate harm and honest mistake, matters. And when the law doesn't reflect that, people start to lose faith in it. They wonder, if intent doesn't matter, what does? If a person who tried their best can still be punished like someone who meant harm, what is justice really measuring? This is where the deeper psychological harm begins. People begin to fear the law not because they're guilty, but because they know they might one day get something wrong. They fear the unknown regulation, the misunderstood rule, the small error that turns into a life-altering charge. And fear doesn't create respect. It creates distance. It turns citizens into suspects. It replaces trust with anxiety. So what should be done? Some argue that strict liability should be limited to truly high-risk fields, areas where negligence can cause mass harm. Others say that the law should include fallback clauses, ways to show good faith effort, or paths to diversion instead of prison. Still others propose hybrid models, strict liability for the act, but flexibility in sentencing, a way to recognize guilt without ignoring intent. Because justice doesn't need to be soft, but it should be human. It should see the difference between malice and mistake. And right now, strict liability laws don't always see that. They punish outcomes, not intentions. And that shift, though subtle, can reshape how we experience the very idea of fairness. Let's return to the man who was convicted. He didn't intend to cause harm. He didn't even know he was breaking the law. But the harm happened. And so the system responded, not to what he meant, but to what occurred. That's the essence of strict liability. It sees guilt in action, not intention. And while that makes enforcement easier, it makes justice harder. It asks us to accept that punishment doesn't always need a reason beyond the result. That morality can be removed from legality. But that's not how most people see the world. We feel the difference between error and cruelty, between forgetfulness and fraud, between mistake and malice. And when the law doesn't reflect that difference, it doesn't feel like justice. It feels like machinery, like something cold, unthinking. So maybe what's needed isn't to abolish strict liability, but to surround it with compassion, with context, with systems that still ask why, even when the answer doesn't change the charge. Because when people are punished for what they didn't mean, they don't learn, they don't heal, they just carry the weight. And that weight doesn't teach safety. It teaches fear. Justice doesn't have to be soft, but it must be honest. And if we truly want a fair system, we can't only look at what happened. We must also ask, who is this person? And what did they mean to do? Because intent still matters, even when the law says it doesn't. Plea bargains, justice or legal blackmail. Why most people confess even if they're innocent. He didn't do it. He knew it. His lawyer knew it. But the prosecutor had a deal. Plead guilty and get 5 years, or go to trial and risk 20. He took the deal. Because sometimes, the courtroom doesn't ask who's right. It asks who's afraid. This is the quiet reality of plea bargains, where most criminal cases never see trial, and confessions aren't always rooted in guilt, but in fear. Fear of losing, fear of longer sentences, fear of a system that feels too big to fight. Let's sit with this. Let's unpack how justice, when filtered through negotiation, can sometimes start to look more like coercion. Let's start with the numbers. In many legal systems, over 90% of criminal convictions come from plea bargains, not from trials. That means most people never have their day in court. They never see a jury. They never hear not guilty or guilty from peers. They just agree. And many of them agree not because they're guilty, but because the risk of going to trial is too high. This is what makes plea bargaining so complicated. It's efficient, but that efficiency comes at a cost. Because when punishment is negotiable, and fear outweighs fairness, the result isn't always justice. Here's how it works. A prosecutor offers a deal. Plead guilty to a lesser charge and get a lighter sentence. Refuse, and face a full trial with the maximum penalty. The gap between the plea and the potential sentence is sometimes enormous. 10 years or 30. Life or death. So the question becomes not did you do it, but are you willing to gamble? And for someone poor, someone scared, someone who doesn't trust the system, the answer is often no, even if they're innocent, because innocence is not a shield. It's a story, and it has to be believed. But the trial is slow, expensive, uncertain, and the court-appointed lawyer has limited time, limited tools, limited hope. So pleading guilty becomes the rational choice. This is what legal scholars call the trial penalty, the extra punishment for exercising your right to go to trial. The system says you're innocent until proven guilty. But it also says, if you want to test that, you'll pay for it. And people do the math. They ask, can I survive 20 years in prison if I lose? Or can I plead, serve 5, and come home? That's not justice. That's negotiation under duress. Let's explore the emotional toll. To plead guilty when you're not, it fractures something inside. It teaches you that the truth doesn't matter, that survival matters more, that your story is too weak to stand against the weight of the state. And when the sentence ends, the label stays. You're an ex-con, a felon, a liar by record, even if not by reality. And society doesn't know the difference. You carry that plea like a scar, not from guilt, but from fear. This is why plea bargains, while efficient, are dangerous, because they reshape the meaning of guilt. They replace deliberation with pressure. They make justice feel like a calculation, not a process of truth. And that changes how we see the system, and how the system sees us. Let's take a closer look at who this affects. Plea bargaining doesn't fall evenly. It hits hardest where the system is already strained, among the poor, the uneducated, the mentally ill, the young. These are people who may not fully understand the charges, or the rights they're giving up, who may not have the resources to fight back. In theory, the bargain is voluntary. In practice, it's survival. The accused sits in a holding cell, waiting for court. Their lawyer visits for 10 minutes. The case won't go away. The evidence might be weak, but the risk is massive. And the state says, "We'll go easy if you say you did it." So they say yes. Not because it's true, but because the alternative is unthinkable. This isn't abstract. It's daily. Thousands of people, every week, plead guilty to crimes they didn't commit, just to get out sooner, just to go home, just to end it. And some never do go home, because even the bargain isn't always what it seems. Some plea deals still include prison time, still result in a criminal record, still limit your rights for life, voting, housing, employment, immigration. And once you plead, the case is closed. No trial, no appeal, no chance to explain what really happened. You signed. It's over. And if you try to fight later, the court often says, "But you agreed." Let's think about what this does to the idea of truth. If justice is about finding out what really happened, plea bargains interrupt that. They shortcut the process. They close the story early. And when that becomes normal, when nearly every case ends this way, something shifts in our expectations. We stop expecting trials. We stop expecting stories. We start assuming guilt. Because why else would someone confess? But confessions don't always mean guilt. Sometimes, they mean exhaustion, fear, a calculation that freedom in 5 years is better than the chance of forever behind bars. That's not a confession. That's surrender. And the system knows this. Judges know. Prosecutors know. Defense attorneys know. Everyone in the courtroom knows that plea bargains are often not about truth, but about time, cost, and efficiency. And yet, they go on, because trials are expensive, courts are backlogged, juries are unpredictable, and plea bargains make things move. But at what cost? At the cost of confidence, at the cost of clarity, at the cost of knowing whether the person who just said guilty actually was. This is the erosion of meaning. A system designed to uncover truth begins to prefer speed. It trades verdicts for paperwork, and in doing so, it loses something essential, the trust of the people it's supposed to serve. Let's return to the man who pled guilty. He didn't commit the crime, but the sentence was lighter than the risk. So he said the words, signed the paper, sat in prison, and came out carrying a truth the system never heard. That's the quiet harm of plea bargains. They turn guilt into a strategy. They make confession transactional. And they teach people that the legal system doesn't care what's real, only what's efficient. So what can be done? Some suggest limits. Cap the difference between the plea deal and the maximum sentence. Make sure the risk of trial doesn't become a punishment for using your rights. Others want more oversight. Require judges to ask deeper questions, to verify that the plea is voluntary, informed, and truthful. Still others propose that we go to trial more often, that we accept the cost and time, because the alternative, mass silent conviction, is worse. Because justice is not about speed. It's about meaning. And when guilt is bought rather than proven, something breaks. Not just in the person who pled, but in all of us. Because we want to believe the system listens, that it separates truth from lie, that it understands fear, and most of all, that it knows the difference between justice and pressure. And until it does, plea bargains will remain what they too often are, not relief, but quiet coercion. When silence equals guilt, legal systems where staying quiet makes you suspicious. He was told he had the right to remain silent, so he used it. He didn't say a word, not to the police, not in court. He waited for his lawyer. He followed the rules. But when the verdict came, his silence was mentioned. If he had nothing to hide, the prosecutor asked, why didn't he speak? And suddenly, silence, once seen as a shield, was reframed as guilt. This is not fiction. In some legal systems, staying silent doesn't protect you, it hurts you. It raises suspicion. It becomes part of the case against you. Let's explore this. Let's sit with the discomfort of a justice system that says, your silence speaks volumes, and none of it in your favor. Let's start with the assumption. In many places, silence is considered a right, a protection, a way to say, I won't speak without counsel. I won't defend myself without preparation. I won't say something that could be misunderstood or used against me. But in other legal systems, or even in certain courtroom cultures, that silence is seen differently. It becomes hesitation, defensiveness, a red flag. The jury listens not just to what you say, but to what you don't. The prosecutor frames the quiet as suspicious. The absence of denial becomes part of the accusation. This is where the idea of fairness starts to bend, because silence is not a confession. It's a pause, a breath, a moment of protection. And when the system turns that protection into evidence, something shifts in the balance of power. It places the burden back on the accused. Prove to us you're innocent. But that's not how justice is supposed to work. In theory, you're presumed innocent. You don't owe the court your words. The state must prove guilt, not the other way around. That's the promise of modern law. That's what makes the system just. But in practice, that promise cracks. When silence becomes suspect, people feel forced to speak, to explain, to clarify, even when they're scared, even when they don't understand, even when they know that saying the wrong thing could make it worse. This creates a quiet kind of pressure, and that pressure doesn't fall evenly. It affects the nervous, the young, the marginalized, people who don't speak the language well, people who distrust the system, people who've been taught that silence is safety. Because for many, silence isn't a strategy. It's instinct, it's fear, it's survival. And when the courtroom doesn't understand that, it turns humanity into evidence. Let's look at how this plays out emotionally. Imagine being on trial. You're told you can remain silent, but then you see the jury's eyes. You hear the way the prosecutor says, he didn't deny it. You feel the shift in the room when you choose to say nothing. And suddenly, your silence feels dangerous. So you speak, not because you're ready, not because it's the right time, but because you're scared that not speaking will be taken the wrong way. That's not justice. That's performance. And in that moment, truth becomes harder to reach because the person isn't speaking freely. They're speaking out of fear. And fear is not clarity. It's noise. Let's examine where this logic comes from. In some countries, the legal system allows silence to be used against the accused. Courts may instruct juries that they can draw an inference from someone's refusal to answer police questions or testify in court. The idea is simple but sharp. If you're innocent, why stay quiet? But that question misunderstands how fear works and how people under pressure behave. Because silence doesn't always mean concealment. It can mean confusion, grief, trauma, or the basic instinct to protect yourself when the rules are unfamiliar. The stakes are high, and the system feels too big to trust. Silence is often a symptom, not of guilt, but of the burden of being accused. And yet, in courtrooms shaped by urgency, that silence becomes another tool, a hook for the prosecution, a whisper that says, "You see, he didn't even deny it." This approach flips the foundation of justice. Now, the accused must not only prove innocence, they must do so loudly, clearly, persuasively, and that's not something everyone can do. Some people are quiet by nature. Some don't trust authority. Some are mentally unwell, overwhelmed, or struggling to understand what's happening. And when silence becomes part of the evidence, the trial stops being about truth. It becomes about appearance. Confidence becomes credibility. Silence becomes suspicion. And slowly, the courtroom becomes a theater, one where silence is no longer allowed to mean restraint or dignity. It must mean guilt. This creates a deeper issue. It teaches people that their rights are conditional. That silence will protect you, unless someone decides it shouldn't. That the right to remain silent is a gamble, not a shield. And when people realize that, they stop trusting the system. They begin to ask, if I do what the law says, and it still hurts me, what's the point? That's a dangerous question, because justice relies on faith, on the belief that the system plays fair, that rights are more than symbolic, that silence is still sacred. When that belief erodes, so does the meaning of due process. People begin to speak not to tell the truth, but to avoid being misread. And when fear shapes speech, honesty fades. Let's not forget that the courtroom is a place of immense pressure. And silence, real silence, is one of the last spaces where a person can hold power. When we turn that into a weakness, we don't just shift the trial. We shift the very meaning of what it means to be heard. Let's return to that moment in the courtroom. He stayed quiet because he was told he could, because he believed it would protect him, because he thought the system would understand. But in the silence, something else took root, doubt. And that doubt, amplified by the prosecutor, echoed louder than anything he might have said. This is the danger. When silence becomes suspicion, the legal system starts to punish people not for what they've done, but for what they've withheld. Not for actions, but for hesitations. And that isn't justice. That's insecurity. A fair system must be strong enough to honor silence, to resist the urge to fill every quiet space with suspicion, to remember that truth doesn't always come loudly. Sometimes, it waits in stillness. So let silence be protected, not just by words, but by understanding. Let it mean what the law says it means, nothing. Because the moment silence is treated as guilt, the courtroom stops listening and starts assuming. An assumption is not justice. It's guesswork. And people's lives deserve more than that. The crime of doing nothing, when not acting is illegal, like failing to save someone. He saw the child drowning, but he didn't jump in. He didn't call for help. He just stood there, watching. No violence, no threat, no weapon, just absence. And yet, he was charged. This is the strange territory of omission, where doing nothing becomes a crime, where inaction, under certain laws, carries the same weight as action, where you can be punished not for what you did, but for what you failed to do. Let's sit with that. Let's explore the legal and moral weight of non-intervention, and how the law, in rare and haunting cases, punishes silence, distance, and the refusal to act. Let's begin with the basics. Most legal systems are built on the idea that you're responsible for what you do, not for what you don't. Crimes usually involve action. Theft, assault, fraud, murder. Something is done. A decision is made. A rule is broken. But there are exceptions. In some places, there are duty to act laws, rules that say, under specific circumstances, inaction itself is illegal. You don't have to be the one causing harm. You just have to be the one who walks away. This is rare and controversial, but it happens. A parent who doesn't feed their child, a nurse who ignores a dying patient, a bystander who watches a brutal attack without calling for help. These aren't crimes of commission. They're crimes of omission. And yet, the damage is real. The law recognizes this in limited, targeted ways. Certain people have legal duties, caregivers, professionals, guardians. If they fail to act, it's not just immoral, it's criminal. But some systems go further. Some countries impose a general duty to rescue. If you see someone in danger, you must help if it's safe to do so. If you walk past, you've broken the law. These are rare laws, but they exist, and they raise uncomfortable questions. What do we owe each other? Just by being present. What counts as help? And where does personal freedom end and social responsibility begin? These questions aren't theoretical. They arise in real cases. A man collapses on a subway platform. Dozens walk past. No one calls for help. He dies. Should they all be charged? Some say yes. That humanity demands it. That society breaks down when we stop seeing each other as worth saving. Others say no. That the law must not dictate morality. That fear, shock, or uncertainty are not crimes. That you can't legislate compassion. Both views have weight. Because omission is slippery. You can't always measure it. You can't always prove it. And not everyone who does nothing is cruel. Sometimes, they're frozen, overwhelmed, afraid, or simply unaware. And yet, when no one acts, harm multiplies. This is the moral shadow of omission. It's not loud. It doesn't break doors. It doesn't leave fingerprints. It just leaves silence. And that silence can echo louder than any crime. The legal system, slow and cautious, rarely enters this space. But when it does so with purpose. It says, in this moment, doing nothing wasn't neutral. It was a decision, a choice that mattered. And that choice has consequences. Let's return to the man who stood by. He did nothing. No violence. No harm. Just stillness. But in that stillness, something was lost, a life, a moment of help, a basic gesture of humanity. And the law responded, not out of vengeance, but out of recognition, that sometimes inaction is not neutral. It's a fracture, a failure that carries weight. That doesn't mean every hesitation should be criminal, but it does mean we should look closer at what silence allows. Because justice isn't only about punishing bad actions. Sometimes, it's about asking why no one moved, why no one called, why everyone watched. And in those rare moments, the law reminds us, doing nothing is still a decision, not with force, but with absence. And absence, too, can leave a mark. Marrying to avoid testifying, using love or fake love as a shield in court. She said yes. The proposal was sudden. No ring, no family, no celebration, just a quiet courthouse ceremony, sealed with a signature. And just like that, she could no longer be forced to testify against him. Because under the law, marriage can sometimes act as a shield, a way to block testimony, a loophole to avoid prosecution, a legal wall built out of vows, whether real or not. This is the quiet strategy hidden inside the idea of spousal privilege, where love, or something pretending to be love, becomes a tool not of connection, but of protection. Let's explore this. Let's look at how marriage, in the eyes of the law, can turn silence into a right and complicity into a possibility. Let's begin with the legal concept. In many legal systems, spousal privilege protects one partner from being forced to testify against the other. The logic is simple on the surface. Marriage is a private bond. Forcing someone to testify against their spouse would violate that intimacy. It would turn love into evidence. But like many legal protections, it can be used strategically. Here's how it works. A person is accused of a crime. The key witness is their romantic partner. Before trial, they marry. Now, in many jurisdictions, that partner can't be compelled to testify. The reason? The law wants to preserve the sanctity of marriage. But the effect? A kind of shield. It doesn't erase the facts. It doesn't make the crime disappear. But it removes one of the most powerful tools a prosecutor might have: the words of someone close. And sometimes, that's enough to weaken a case. Some couples marry for love. Others, for protection. Sometimes both. The law doesn't ask how deep the love is. It just asks if the paper is signed. That's what makes this complicated. Because while the protection is real, it can also be manipulated. Marriage becomes less about commitment and more about silence. About sealing lips. About avoiding courtrooms. And in rare cases, it works. But it's not universal. Some countries have tightened the rules. Some don't recognize spousal privilege in criminal cases. Others allow it only for events that occurred after the marriage. Some require the privilege to be waived in domestic violence cases. Still, in many places, the old rule stands: if you're legally married, you don't have to testify. Let's consider what that means emotionally. The courtroom is already a complex place. People carry fear, memory, shame, conflict. When you add a relationship, especially one reshaped by strategy, it becomes harder to know what's real. Did she marry him to protect him? Or because she loves him? Did he propose to silence her? Or to keep them together? Is this marriage a shield or a trap? These are not questions the law is built to answer, but they linger in the background, in the courtroom, in the headlines, in the minds of jurors. Because marriage, when used as a tactic, changes shape. It stops being personal and becomes procedural. A tool, a move, a legal maneuver. And that maneuver affects more than the case. It affects the meaning of marriage itself. It raises questions about trust, intention, and how far people will go to avoid accountability. It doesn't happen often, but when it does, it reminds us that even love, real or feigned, can be part of the strategy. Let's return to that quiet courthouse. They signed the paper. They said the words. And in doing so, she gained something rare in the legal world: the right to say nothing. And maybe she used it, not out of loyalty, not out of love, but out of something harder to name: a mix of fear, protection, and unfinished feeling. This is the strange power of spousal privilege. It protects connection, but sometimes it protects control. It honors intimacy, but sometimes it enables silence where truth is needed. And the law, trying to balance privacy and justice, stands in the middle, not questioning the love, just respecting the paper. But paper can't always speak for the heart. And when silence is bought with a vow, we're left with a question that the court can't answer. Was this marriage a commitment or a shield? And what does it mean when the law allows it to be both? Suing for emotional distress from a crime you caused. Absurd lawsuits where criminals want sympathy. He broke into the house. He held them at gunpoint. He left with their cash, their jewelry, their peace of mind. Then, weeks later, he filed a lawsuit. He claimed he was traumatized by the experience, that the stress of committing the crime had damaged his mental health, and that the victims owed him compensation. It sounds absurd, but it's happened. This is the strange edge of the justice system, where the person who causes harm tries to claim injury, where the criminal plays victim, and where the law, in some cases, has to listen. Let's unpack this. Let's look at the few bizarre moments where the guilty ask for sympathy, and the court is forced to consider it. Let's begin with the principle. In most cases, the law separates wrongdoers from victims. If you caused the harm, you can't ask for comfort. If you created the chaos, you don't get to sue for the noise. That's the foundation. Responsibility cancels entitlement. But in rare and surreal cases, that line blurs. There have been lawsuits where burglars claim to be emotionally scarred by the people they robbed. where a trespasser sues a homeowner after getting injured on their property, where a criminal blames the trauma of their own actions on the people they targeted. And while most of these cases are dismissed, some are not, because the law, by design, tries to stay neutral. It listens to claims. It weighs them on legal grounds, not moral ones. And that neutrality, though essential, opens the door to strange possibilities. A man breaks into a store, gets trapped in a freezer, sues for psychological distress. A thief injures himself during a getaway, claims the victim's dog was too aggressive. A con artist files a suit, saying the pressure of pulling off the scam gave him anxiety. These cases make headlines. People laugh. Outrage follows. But the fact that they reach court at all reveals something deeper. The law doesn't always filter for character. It filters for argument. If the legal structure allows it, even briefly, the case can exist. That's the tension. Because courtrooms aren't morality plays. They're forums. They process claims, even offensive ones, according to rules. And those rules, while necessary, can sometimes produce outcomes that feel absurd. Let's go deeper. Why would a criminal sue the person they harmed? Sometimes it's strategy, a counterclaim to intimidate, a distraction from the real case, a way to delay proceedings. Other times, it's delusion, a distorted sense of justice, a belief that the consequences they now face must be someone else's fault. And occasionally, it's just performance, a public spectacle, an act of defiance wrapped in legal paper. But behind it all, there's a larger question. What does the court owe people who did wrong? Are they still entitled to voice harm? Is there a point where empathy ends? The answer is uncomfortable. Even the guilty are human. Even criminals have rights. And the legal system, at its most disciplined, refuses to abandon that truth. But there's a difference between rights and reversals, between listening to someone and allowing them to rewrite what happened. So when these lawsuits arise, the law walks a narrow path. It hears the case, but it rarely bends. It allows the argument, but holds the line. Still, the fact that it must do so at all reveals a core fragility. That fairness includes everyone, even those who tried to break it. Let's return to the courtroom. The criminal sues. The claim is read aloud. The victims sit and listen. The judge frowns. The lawyers argue. And in that room, something fragile is tested, the patience of justice. Because law, in its purest form, is not about feeling good. It's about being even when the balance looks absurd, even when the claim feels insulting, even when the one who caused pain says, "What about me?" The system must still answer, not with emotion, but with order, not with sympathy, but with structure. And that is both its strength and its strangeness. Banning thoughts, hate speech versus free speech. When saying certain words becomes a crime, but only sometimes. He didn't touch anyone. He didn't steal, break, or burn. He only spoke loudly, offensively, carelessly, and still, he was arrested, because in that moment, speech itself became the crime. This is the tension at the heart of modern law. When does speech cross the line into harm? When do words become weapons? And how can a society protect freedom of expression without also protecting hate? Let's sit with this contradiction. Let's explore the legal paradox of banning ideas in a system built to protect them, and how the same words can be criminal in one place and protected in another. Let's start with the foundation. Free speech is a pillar of modern democracy. The idea that you can say what you believe, even if it's unpopular, offensive, or uncomfortable, is central to the concept of a free society. It protects dissent. It protects disagreement. It protects the ability to question power. But that freedom isn't absolute. In many countries, certain types of speech are restricted, not for being rude or controversial, but for being dangerous. Hate speech, incitement, threats, defamation, These are where the law steps in and says, words can hurt, and when they do, they can be punished. This is where the line gets blurry. What counts as hate? What qualifies as incitement? And who gets to decide? In some places, the standard is high. Only speech that directly causes harm, like calling for violence or targeting someone's safety, can be punished. In others, the bar is lower. Words that insult, degrade, or offend certain groups may be criminal, even without a direct call to action. This creates confusion. The same phrase might be legal in one country, but illegal in another. A tweet, a chant, a poster, protected by free speech in one courtroom, punished as hate speech in another. And people notice, because laws that regulate speech often reflect not just legal priorities, but cultural ones. What one society sees as a threat, another sees as discourse. What one court punishes, another defends. This is the paradox. Free speech allows people to say dangerous things, but limiting speech risks suppressing necessary ones. Silence the hate, and you risk silencing dissent. Leave it alone, and you risk letting it spread. There's no perfect solution. Every approach comes with trade-offs. Let's think about the emotional weight of this. Imagine being part of a community targeted by hate speech. The words are constant. The slogans are cruel. The message isn't abstract, it's personal. And the law says it's free speech. You feel unprotected, invisible, as if the rules were written for someone else. Now imagine being on the other side. You speak critically. You question a cultural norm. You use harsh words, but not hate. And suddenly, you're accused, investigated, fined, maybe even arrested. Now you feel censored, misunderstood, like the law is more about mood than meaning. Both sides feel betrayed, because when the law becomes the referee of ideas, it starts judging intent, and intent is slippery. One person's satire is another's slur. One person's warning is another's threat, and the courtroom is forced to ask impossible questions. What did you mean? What did you feel? What was in your mind? That's not a legal standard. That's psychology, and it makes law feel arbitrary. Let's return to the speaker. He said something ugly, loud, public, and now he's in court. The judge reads the words. The jury listens. The question isn't just what he said. It's why he said it, and whether it crosses the invisible line between idea and injury. This is where modern justice stands, between protection and expression, between harm and honesty, between thought and punishment. And that line, wherever it's drawn, is always moving. Let's push this further. What happens when society becomes afraid of speech itself? When language, once a tool of dialogue, starts feeling like a threat. We see it in universities banning speakers, in protests silenced by public order laws, in countries where journalists are imprisoned not for lies, but for tone, and even in democratic courts. We now see trials that hinge not on what someone did, but on how their words were received. This is the shift from behavior to belief. We're not just punishing what was said, we're interpreting why it was said. Courts weigh tone, history, social meaning, and in doing so, they move into fragile territory. They start trying to read minds. But can the law really understand what someone meant? Can a system built on evidence now work with inference? That's the risk, because meaning changes. Words evolve. Context varies wildly across cultures, communities, and histories. A phrase one group hears as satire, another hears as violence. A joke becomes a threat. A metaphor becomes an attack. And once the state begins to punish ideas, not actions, not outcomes, but ideas, we must ask what stops it from going further. Because the logic cuts both ways. If hate speech laws are meant to protect, they can also suppress. Today's protection could be tomorrow's silence. A rule meant to shield minorities could later be used to silence dissenters. What begins as compassion can shift into control. This is why some defend unrestricted speech, not because they like hate, but because they fear censorship even more. They say, let the ideas come. Let them be exposed. Let society reject them. But let them be spoken, so we always know who is thinking what. But even that has limits. Because exposure doesn't always weaken hate. Sometimes it spreads it. Visibility gives voice. Algorithms amplify outrage. And before long, the ugliest speech becomes the loudest. So we return to the courtroom, torn. On one side, protect the vulnerable. On the other, protect the speaker. And both believe they are guarding justice. Maybe this is why the line keeps moving. Because it isn't a legal line at all. It's a cultural one, drawn not in codes or statutes, but in fear, memory, trauma, and power. And in every country, that balance looks different. Some favor safety. Others, liberty. Some fear the past repeating. Others fear losing the right to protest it. And the law, stuck between all of them, tries to write a rule book for what should never have been a rule. Because speech isn't a fixed thing. It's fluid, emotional, explosive. And the moment the law tries to freeze it, define it, ban it, it steps into a storm it cannot control. And maybe the deepest question is this: do we trust people to speak? Or do we trust the state to decide what they can't? There's no simple answer. Only a fragile, moving threshold. And every time a new word is banned, or protected, or punished, that threshold shifts again. And behind it all, behind every trial, every law, every protest, is the same unsettled truth. Speech is not just what we say. It's who we are. And any law that governs it must tread lightly, or risk silencing far more than sound, being punished for the same crime twice. The hidden ways double jeopardy gets bypassed. He was tried, acquitted. The courtroom doors closed. He went home thinking it was over. But then it wasn't. A different charge, a different courtroom, a different name for the same event. And suddenly, he was back on trial for what he thought he'd already survived. This is the hidden edge of double jeopardy, the legal principle that you can't be punished twice for the same crime, a cornerstone of fairness, a guardrail against state power. But like many rules, it bends, and sometimes it breaks. Let's sit with this. Let's explore how the system, while claiming finality, sometimes finds its way back in through loopholes, reinterpretations, and names that don't quite match the crime. Let's start with the ideal. Double jeopardy exists to protect individuals from repeated prosecution. It says, once the state has made its case and lost, it doesn't get another chance. You can't keep dragging someone into court until you get the outcome you want. It's a principle of closure, of peace, of protection from the full weight of government power. But it's not as absolute as it seems. Because the law doesn't only speak in absolutes, it speaks in definitions. And definitions can be reshaped. Here's how double jeopardy gets bypassed. Sometimes, the same act is carved into multiple crimes. A person is acquitted of murder, but later charged with federal civil rights violations based on the same event. Different laws, different charges, same facts. Sometimes, the case is picked up by another jurisdiction. State acquittal becomes a federal indictment. Country acquittal becomes international trial. The person walks out of one court, only to be summoned by another. Sometimes, it's a civil suit. You win your criminal case, but now face financial ruin in civil court. Same actions, different stakes. You don't go to prison, but you lose everything else. These are the hidden routes. They're legal, but they feel off, because the person thought they were done. They faced the system. They heard not guilty. They exhaled, and now they're back. Let's talk about the emotional impact. Imagine thinking the worst is behind you. You survived the headlines, the trial, the strain. You rebuilt your life. And then, a letter arrives. Another trial, another courtroom, another attempt to reframe the past. It doesn't feel like justice. It feels like revenge. And even if it's framed differently, new charge, new name, the weight is the same. You're on trial again. Let's go deeper. Sometimes, the system doesn't try again through court. It does it through punishment. You're acquitted, but the state still punishes you indirectly. You're denied licenses, flagged in databases, kept from jobs. Your name never really clears. You're free, but marked. This is the shadow version of double jeopardy, where the punishment continues, even after the verdict says it shouldn't, and the law allows it, because the courtroom and the system aren't the same thing. One closes, the other lingers. Let's return to the ideal. Double jeopardy is supposed to protect people from endless prosecution, from being ground down by a system that refuses to accept loss. But in practice, the system has other tools, new charges, new venues, new frameworks, and each one chips away at the promise that not guilty means finished. That's what makes it dangerous, because justice isn't just about verdicts. It's about peace. And when the law finds ways to reopen what it promised was closed, it creates a different kind of punishment, not in prison, but in permanence, because the case ends, but the process doesn't, and a person can spend their life free, but never fully uncharged. Let's step into the courtroom again. The judge says, "This is a different case." The prosecutor says, "It's not about the same crime, it's about a different harm." The law agrees. Technically, the charges are reworded. The statute cited is different. But the story, the event, the experience, it's the same. This is the quiet betrayal of technicality, because language bends. And when law relies on language, it can be made to say almost anything. A single event is sliced into legal fragments, each one small enough to be retried, redefined, relitigated. The system doesn't call it double jeopardy, but the person living it knows. This isn't a new trial. It's a return, and it doesn't always involve courtrooms. Sometimes, it's institutional. A person is found not guilty, but their school expels them. Their employer lets them go. A visa is denied. A reputation is shattered. And the explanation is always the same. We're not judging you for the crime. We're protecting ourselves. But functionally, it's punishment, because being acquitted didn't erase the suspicion. It didn't erase the risk. It didn't erase the record. The trial ended, but the consequences multiplied. So what is double jeopardy, really? Is it just a courtroom rule? Or is it a promise that after being judged, a person can move on? If it's the latter, then the loopholes matter, because they tell a deeper story. That judgment doesn't always end with judgment. That punishment can take new shapes, and that once you're caught in the system, it rarely lets go. This doesn't mean guilt or innocence. This is about process, about how final something can feel and still be reopened, about how a verdict can sound like closure, but operate more like a comma. And that's the hardest part, because double jeopardy is supposed to protect against state power, but sometimes it fails to protect against legal creativity. New statute, new term, new courtroom, same weight. And the person, once again, has to prove what they've already proven, not because they did something new, but because the system found a way to ask again. And in that asking, there's a quiet erosion of trust, in justice, in closure, in the idea that finished should mean finished. Revenge porn and the battle of consent. Who owns your image after a breakup? They trusted each other. They shared photos, videos, private moments built on affection. Then the breakup came, and those images, once shared in intimacy, were posted online for strangers to see. He said it was just payback. She said it was a violation. The law called it something else. Revenge porn. It's not about nudity. It's not about sex. It's about consent, given in private, then weaponized in public. It's about who owns your image when the relationship ends, and whether trust can be protected after love breaks down. Let's explore this. Let's look at how the law tries, and often struggles, to define where intimacy ends and exploitation begins. Let's begin with what makes revenge porn so complex. Unlike hacking or stalking, revenge porn often begins with consent. The photos were shared willingly. The moments were mutual. There was no deception until the relationship ended. That's what makes the betrayal so sharp. It's not just exposure. It's transformation. Something once rooted in connection is repurposed for humiliation. A private act becomes public shame. And the person who once held your trust now holds your vulnerability. This is why the law struggles. Because the legal system is built to punish crimes with clear beginnings, a break-in, a theft, a threat. But revenge porn blurs the timeline. What was legal at first becomes illegal later, not because of the content, but because of the context. And context is hard to legislate. Some countries have criminalized it directly. Others haven't caught up. In many places, victims must rely on outdated harassment laws or try to sue under vague privacy claims. The burden falls on them to prove that something once shared became something weaponized. Let's talk about consent. Consent is not permanent. It's not a contract that survives every argument, every betrayal, every ending. It's dynamic, ongoing, and it can be revoked. But the law doesn't always treat it that way. Often, the person who distributed the images says, "She sent them to me. I had the right," as if ownership of an image means ownership of a person's dignity. As if affection, once given, can be used however you like. That's the heart of the problem. Because revenge porn isn't about sex. It's about power. It's about control, humiliation, retaliation. And the damage isn't just emotional, it's permanent. Images, once online, rarely disappear. They spread. They resurface. They outlive the pain that caused them. Victims lose jobs, relationships, peace of mind. They spend years trying to erase something that never should have been public. Let's explore what justice could look like. Some say we need stronger laws, clearer definitions, harsher penalties, faster takedown systems. Others argue for education. Teach people what consent really means, even in digital spaces. Still others focus on platform responsibility. Make the sites that host these images accountable. But all of it returns to one question. Who owns your body, digitally? If you shared an image of yourself in trust, and someone else shared it again in anger, whose rights come first? The law is still learning how to answer. Because revenge porn exists in a space the law wasn't built for. Private emotion turned public evidence. Intimacy turned into weaponry. And the scars it leaves are quiet but deep. Let's return to her. She didn't just lose privacy. She lost control over her image, her story, her memory of a relationship that ended not with silence, but with spectacle. And that's what makes revenge porn so devastating. It's not just a crime. It's a betrayal that keeps showing up every time someone else clicks.